at Calcutta, Your Honor. We will stay at Pradhannagar. Chalo, 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 chalo.
The name is spelling mistake, my lord. Only
Yes, spelling mistake. Learned advocate appearing for the state
and how it is spelling both mistake.
submit aids the act. There is a discrepancy in the name of the learned advocate appearing on behalf of the state. The names of the learned advocates appearing should be read as correct spelling. This may be treated as part and parcel of the order dated 17/6/2020 A5. Department is directed to incorporate necessary corrections.
Obliged, your lordship.
Yes, sir.
Your Lordship, on the last occasion, written notes of arguments were submitted by both the state and the petitioners.
Alright, এদেরটা কোথায়? রিট নোটস গুলো কোথায় আছে? কোনটায় আছে? Alright, tomorrow I'll pass the orders.
Lordship.
Grateful, Your Lordship.
Tomorrow I'll pass the order. Either দিয়ে দেবেন না?
Item 2 and 3 both are.
Both, tomorrow. Not today only, tomorrow I'll pass the orders.
Number 4.
I'm for the petitioner, my lord. Item number 4 and 5, my lord. It is
Lordship, the investigating officer along with the case jury is here.
Why didn't he appear when your office sent him notice asking?
Lordship, I have already asked Lordship, his previous police station did not communicate the same to his new place of posting.
No, that.
Yesterday we called him and informed, and today he is present.
What is the case? Give the CD.
Lordship.
What is the stage of the case in the trial court? 1 year, more than 1 year, 11 months in
Lordship,
custody.
what happened as per his reported in? Lordship, several applications were filed on the juncture when the evidence were recorded and the case diary was called for, and as such the witness could not be
Examined.
examined as per the state. On the previous rejections.
Where was it filed?
Here.
Here.
Huh? Yes, Lordship. Previous rejections orders are there.
My lord, there have 6 accused total. And my lord, already 2 are on bail. my
Lordship,
lord.
here are all the copies.
I am also, my lord, submitted the bail order, my lord.
Lordship, here are all the copies.
My lord, both persons name not in FIR, my lord, not in 164, my lord.
So strategically you are killing time so that you can obtain bail.
No, my lord, it's not our fault, my lord.
13th.
Who is appearing for the other side? Affidavit of service? Affidavit of service?
Saurav Ganguly appeared from.
No, I'm for the state.
हाँ. Only state is the party?
Yes, your lordship.
Huh?
Yes, your lordship.
What case?
2013 my lord, the person concerned my lord,
Case is what? I am asking you sections.
NDPS case my lord.
NDPS stay হয়ে পড়ে আছে?
My lord, may I? 2013 my lord,
Vehicle.
vehicle my lord, 2013 my lord, I have.
Vehicle?
Yes,
কেন
your lord.
they- The
I-
whole case stayed?
No, Chief.
Yes. Huh?
পুরো case stay হয়ে গেছে।
No, no, only for me my lord.
আরে, you are an accused in the case or no?
I am not the accused
He was
person. my
not
lord.
cited as, he was the owner of the vehicle.
My lord, 2000
Maybe that is a.
But not
in all-
cited as a
In
witness.
all cases, need not be according to the investigation.
Lordship.
Alright, the interim order earlier granted aid is extended aid till 31st of July 2025. Let the revisional application appear before the next available circuit bench under the heading contested application.
Anthony now.
তো কিছু নেই না? হ্যাঁ, accordingly, CRAN number 11 of 2025 is
12
disposed-
minutes.
12,
Yes, your lord.
CRAN number 12 of 2025 is disposed of.
Deeply
Other
obliged.
copies. Chalo, next.
For the petition.
Well, I'm for the petition.
Who's the other side?
Well, I serve once,
Mr. Bhattacharjee, you are appearing in this, you are appearing in this matter. Mr. Bhattacharjee,
I served to
you
go,
is appearing with Mr. Nilay Chakraborty in this matter.
not only that, I also served to police, pursuant to last order, my lord.
What case?
But this is what happened, my lord,
GR case or PS case? CR case?
this is GR case.
GR case.
So I have given to-
The petition I made out. Okay.
Yours is the last order 29th for April.
The interim order earlier granted aid is extended. You have taken within time, Naki?
Yes, sir. wasn't there?
Huh?
We will, sir.
8 weeks, sir. Yeah. The interim order earlier granted is extended till 31st of July 2025. Let the revisional application appear before the next available circuit bench. Server copies.
I serve again, my lord. I serve again?
Whom?
No, I am served. The police is likely to serve.
No, his name is appearing in the order sheet. I
It's
don't-
not as the private opposite party. The police is directed to serve.
You made them party.
Yes, yes.
আচ্ছা ওই একটা দিনের petition is to serve afresh upon the opposite party number 2 by speed forth with AD and file affidavit of service on the next.
Yes, ma'am. But the police is directed to serve.
Afresh.
Yes.
Next, তাতেই.
I'm grateful.
আরে বাবা. Who is appearing on the other side?
My lord, private party, state, everybody served.
Private party? Private
Yes,
party?
Yes.
State? State is necessary party কি?
Subba was there in this matter.
GR case?
Yes, GR case, POXO.
ও বক্সতে কি স্টে নিয়ে বেরিয়ে গেছে? application. Application for bail in the next available circuit bench. Chalo. Next.
My lord, I am for the
I'm
petition.
for the state.
Ready? Ready?
NDPS now.
Very good.
100 bottles of cough syrup allegedly recovered from the possession of this accused petitioner. Search and seizure done in between 1:15 hours.
So do it in the next circuit. 23rd April, it has been rejected.
Yes,
Rejected.
Do it in the next circuit. For you only, I am telling. Learned advocate 8 for the petitioner is present. Close proximity of time is very difficult. Learned advocate 8 for the petitioner is present. Petitioner as well as the state is present. Having considered that
so all procedure,
huh?
all procedure has been fulfilled as per provision.
No, I know.
There is no scope.
Let him try his luck before the next circuit bench. In view of certain documents required to be placed before the court, list the bail application before the next available circuit bench.
Grateful.
I am grateful to you, Lord.
Lordship, I am for the petitioner.
Nobody is appearing for the state.
Lordship, 1 liter 300 ml.
Who is appearing?
No. 17.
You are appearing.
Yes, yes, madam.
Please start the case, you bring the case. diary.
Lordship,
Have you got the case diary? Okay, good.
Lordship, allegation is that 3 accused persons were apprehended. Lordship, first of all, I may place page 7, previous rejection order, Lordship.
When?
Lordship,
In
page
2019.
7, kindly sees, page 7 is the previous rejection order. Rejected on February. And page 9, Lordship, page 9 is not a rejection order, but we prayed regarding the illness of mother. Honorable Court in para 7 gave us the opportunity
How
to
much is
move
the recovery?
1 kilo 300 ml, 1 liter 13 ml, 1300 ml. But Lordship, one thing,
300 ml cough syrup from the position of this.
3 accused persons,
3 accused persons.
3 accused
Just
persons.
above the commercial point.
Just.
Yes, my lord, above commercial quantity.
4-5টা করে বোতল ডিস্ট্রিবিউট করে দিয়েছে।
Only 3
No, no, no.
bottles, Lordship, that is
3
the
bottles
thing.
and in
One,
fruit juice, 1 liter fruit juice, they.
Fruit juice bottle, but that has not been sent for FSL, Lordship,
Yeah,
but
yes.
that incorporated.
ঠিক আছে, ওই কবে থেকে আছে? অনেক দিন ধরে আছে।
Lordship,
সেপ্টেম্বর।
Lordship,
My lord,
সেপ্টেম্বর তো।
yes, my lord, and next date fixed.
4th September,
চার্জ ফ্রেমড।
No, my lord, next date.
How many
fixed on
witnesses?
10th June. 13 witnesses.
31st December 2024, charge sheet
10th
submitted.
July fixed for charge.
চলো বেরোবি, লোকাল সিকিউরিটি দিলে বেরোতে পারবো, টাইম লাগবে এখন। আচ্ছা, learned advocate appearing for the petitioner submits that from 3 accused persons, 1308 ml of cough syrup was recovered, and the present petitioners are in custody since 3rd of
November.
3rd of September 2024. Full stop. Additionally, it has been submitted that although charge sheet has been submitted, but till date charge has not been framed. As such, the petitioners on any condition may be released on bail. Learned advocate appearing for the state opposes the prayer for bail and submits that date has been fixed for consideration of charges on 10th of July 2025. Acha, I find that there are 13 witnesses on which the prosecution has relied upon to prove its case, having regard to the fact that if 15 witnesses, sir, not
13 witnesses.
You or see your charge sheet.
15 witnesses. Last is SI
Hello,
Indro Tamang.
In my charge sheet,
Hey,
13.
Indro Tamang. Lordship in his 13.
No, maybe the FSL report has subsequently come. in.
Subsequent.
Yes,
Witnesses have been added.
maybe.
So 15 is the final.
No, no.
No, no, 1, 2, 3, 4, 5, 6, 7, 15.
15 witnesses, chalo,
One accused on bail, Lordship.
15 witnesses are to be examined. Now, sentence of total thing, Lane advocate for the state. I find
No, it.
I am of the view that there is no scope of the trial being completed in near future.
Charge sheet number 173. 73.
According to tujhe alaga.
Charge sheet number same, but 13 again 15.
Kalingpong.
Copy sublight 15.
The prayer for bail of the petitioner, the allowed petitioner shall furnish bond to the satisfaction of the learning.
Good.
Bond to the satisfaction of the learning aid special court,
Kalimpong.
NDPS Act, Kalimpong. By yeah. Kalimpong, the learned court would decide regarding the quantum of the bond. However, there should be two sureties, one of whom must be local. Full stop. One of whom must be a local surety. Next, so far as the case is concerned, the local surety in this case would be of a person who would have a property and would submit his title deed, who would have a property within the jurisdiction of the learned special court Kalimpong and would submit the title deed of the property for ensuring the appearance of the so এটা পরে পেয়ে তো হতো না আমি বলছি টাইটেল ডিড থাকলে একটা ভয় থাকে
Well, they are from.
So one accused is on bail.
They belong to Sikkim.
তো দেন
Yes.
লোকাল সিওরিটি পেয়ে যাবে ওরা আচ্ছা the petitioner shall make themselves available before the learned aid special court physically on each and every date and shall not leave the jurisdiction of the district of Kalimpong without the leave of the special court. Full stop. And to issue the document with the aforesaid observation, CRM NDPS number 260 of 2000.
Deeply obliged, Lordship.
Grateful.
Eighteen who's appearing for the state. The NCB though, how can he be? This is the NCB case, Union of India will appear.
What is the name of the petitioner? Suranjan Burman.
Yes, your lordship.
এসা আছে the file.
So 18টা এটা অন্য ফাইল দিয়েছেন। অন্য ফাইল দিয়েছেন।
NGB GRP case number 1 of 2024.
Yes, what is there?
Yes, your lordship.
25.80 kgs of gaja.
Yes, your lordship.
Investigation completed.
Yes.
Yes, your lordship. It has been completed, your lordship.
How many persons?
2 persons, your lordship. From 2 persons, 25.8 kgs gaja, your lordship.
So, কতদিন আছে?
157 days, your lordship.
না, after framing of charge, not now.
Your lordship, kindly consider, your lordship.
Learned advocate appearing for the petitioner submits that the petitioner is in custody for about 157 days. And allegedly there have been seizures from 2 persons, including the petitioner. For about 25.800 kg of contraband of the gaja. Having considered the fact that the charge sheet has already been submitted and the copies are yet to be supplied to the accused persons. I am of the view that the petitioner has be granted liberty A to renew their prayer for bail after the stage of consideration of charges are over. Sure, next, according to CRM number, ওই এটা কত আছে? NDPS 264 of 2025 is dismissed. Next.
Next circuit, my lord.
Well,
PD has not.
Learned advocate for the petitioner is present. Learned advocate 8 for the Union of India prays for an accommodation. List the bail application before the next available circuit bench. Next.
Lordship, in item number 20, I am appearing on behalf of the appellant petitioner. Would be very grateful if your lordship kindly place this matter before the next available circuit bench.
Learned advocate 8 appearing for the petitioner is for
For the state.
an accommodation. List the learned advocate for the state is present. List the bail application before the next available circuit bench. Next.
Hey, not time for the petition. My lord, 27.9 kg of gaja has been
20?
recovered. My lord, charge sheet submitted on
27
0.9 kg. My lord, charge sheet submitted on 31st of May 2025.
arrested when?
My lord, arrested on 21st of March, 90 days custody,
recent,
21st
my
of
lord.
March 2025. My lord,
There is an
my lord, give
earlier
me, my lord,
arrest and they-
my lord, let me place my case, my lord.
Please.
My lord, in this case, my lord, that is connection with Sahibganj PS case number 153, 2025. My lord, police had been arrested once Shakil Sheikh. And my lord, at the time of interrogation, Shakil Sheikh had been told that police, my lord, that he has stored some ganja in the premises of petitioner. My lord, kindly see page number 15 and 16, that is the FIR, my lord. He has been categorically said, my lord, he have been stored the ganja in the premises of the petitioner.
After where is the season list? Where is the season list?
Give me some, 1 second. My lord, page 18, my lord,
18.
page 18.
Recovered from where?
Recovered from the premises of the petitioner.
Exclusive position, my lord.
Thereafter, my lord, page
Yes.
12, my lord,
My lord, I am
page 12, my lord. My lord, there is a rent agreement from the year of 2024.
question of-
all
My
of
lord,
the matter
rent
of
agreement, my lord.
hell, my lord, and
Learned advocate 8 appearing for the petitioner submits that the petitioner is in custody.
My lord, let me,
for
my lord,
90
another point,
days.
my lord. I have another point, my lord. My lord, if your lordship kindly peruse the, my lord, Caesar, my lord, the arrest memo. In the arrest memo, my lord, it has been stated the petitioner have been violated on the ground of arrest. The petitioner have violated the section 42 of the NDPS. And my lord, section 42 of the NDPS clearly says that, my lord, the authorities empowers to the officer to search and seizure. How can that be a ground for ground, my lord?
Young,
My lord, at the time of arrest, in the arrest memo.
legality of the ground of arrest.
Yes, my lord.
Legality of the ground of arrest, Caesar was affected, how can you say now?
My lord, my premises were rented by the Sheikh Shakil Sheikh, my lord, there is a.
Your document of rent is a question
Yes.
of fact, sir.
fact and this trial. and-
Fact, whether that is your house or not your house, may not be your house also.
But
My
your
lord,
conscious position, it has.
But one person has said that and another.
My lord, he had been said that he had been stored some ganja in my premises. My lord, there is a rent agreement. He not said, my lord, we are having our business together. My lord, he in his FIR, he has clearly stated that, my lord, he stored
How
some.
can you allow somebody to store gaja in your premises?
How could I know, my lord, if someone is, my lord, give me, my lord, how could I know, my lord, if someone is rented my premises and stored the ganja, my lord, I have no.
Take up the point.
It's very good arguable case, but at the time of trial, not at this stage.
My lord, only 27 kg of ganja, my lord. Charge sheet has
I
already
understand, I could
submitted.
have, but you could have come after some time. sir.
Sometimes, my lord, all
After
the
some time.
considered after sometimes.
After 6 months, usually I grant only because of the reason that is a failure of the state for not starting the trial. But as a matter of right, in commercial quantity, you cannot claim that.
Yes, lordship.
You will-
My lord, it is not my premises. And my lord, there is also violation of Vian Kumar judgment, my lord.
Huh? No. Petitioner is in custody for 90 days. And the seizure was on the basis of the statement of co-accused.
And my lord, also Shakil Sheikh has been granted bail, my lord, from whom?
Maybe he's not his position, position is zero.
There is my order of the Shakil Sheikh, my lord, if your lordship kindly take it. from whose mouth my name has been stated, my lord, he has been granted bail by your lordship. In connection with this case, my lord.
Annex করেছো?
But
Yes, sir.
no recovery was from him.
Yes, my
Lordship.
lord.
That is the reason why. Not standing in the same footing.
Huh? Caesar. কি বললেন? Wait, please. Acha, it has also been submitted at the amount that the quantum of recovery E was to the tune of rupees 27.9 kgs. And the petitioner's premises have been shown to be the place of occurrence for place of seizure for which the petitioner has been arraigned and arraigned as an accused and detained in connection with the incident case. Learned Advocate 8 has therefore two certain documents. I've considered the document which is photostat copy of a notarized document. Full stop. Learned Advocate 8 for the state has produced the case diary. I have considered the materials on record. And I find that the present petitioner is situationally not similarly situated as that of the other accused, namely Shakil Sheikh. As no recovery was made from the possession of the state accused, while recovery has been made from the house of the present petitioner. Having considered the same, I am of the view that this is not a case for granting bail at this stage. Petitioner would be at liberty to renew the prayer for bail after consideration of charges. Children, according to CRM NDPS 267 of 2025, is dismissed. Who's there? 22 কেউ আছে ওখানে? Virtually আছে 22. Huh? Circuit. Learned Advocate 8 for the petitioner prays for an accommodation. Learned Advocate for the state is present. List the application before the next available circuit bench. Next.
My lord, 23, my lord. My lord, I'm for the petitioner, my lord. This is a quashing of a proceeding, my lord, under section 318, my lord, that is 420 and 406, my lord. My lord.
Sir, liberty to stay upon after effecting service.
My lord, only one thing, my lord, civil suit already pending, my lord.
Very good. Petitioner is directed to serve a copy of the revisional application upon the opposite party number 1 to the office of the additional public prosecutor, Circuit High Court at Calcutta, Circuit Bench Jalpaiguri, and upon the opposite party number 2 by Speed Post AD, and file affidavit of service on the next hearing. List the revisional application before the next available circuit bench. Petitioner's for interim order will be considered after a service has been effected on the opposite parties. Chalo. Next. None appears for the petitioner or the state. List the revisional state. None appears for the petitioner. Revision application. As such, list the revisional application on the next available circuit bench. Next.
My lord, 25, I'm for the petitioner, my lord. Counter blast, my lord. Yes, my lord, 25, my lord.
কোনটা অর্ডার গেল গন্ডগোল হচ্ছে? আচ্ছা 25, হ্যাঁ, yes.
Yes, my lord. My lord, I am the wife.
Sir, same order. Sir, interim order will be considered.
My lord.
ঠিক আছে, next. 26. Learned Advocate 8 for the petitioner prays for an accommodation. This the revisional application before the next available circuit bench. Next.
27, I appear, my lords.
Yes.
My lords, this is a revision against, my lords, a rejection of discharge order, my lords.
Section 5, serve and then come.
Please, my lords.
And a copy is not served. The application, the revisional application is accompanied by an application for condonation of delay.
My lords, 27, my lords, sorry. There is no condonation in 27, my lords.
So what is the CRN for?
My lords, for the stay of the proceedings, my lords.
So then servant come. Thank you, file for stay alert. The learned advocate aid for the petitioner is directed to serve a copy of the revisional application along with the connected application upon the না আমি চলতে এটা দেখে নিই একটা মিনিট on the you have entered appearance. You are
CBI.
entering appearance.
CBI, Lordship.
You are entering, give your name. Upon the learned advocate who has entered appearance on behalf of the CBI. Full stop. Release the revisional application before the next available circuit bench. The prayer for entry order in CRA in 1 of 2024 would be considered after the revisional application along with the connected application is served on the learned advocate appearing for the state.
Grateful, my lords. Grateful.
Upon the state.
Sir, 28, I am for the petitioner, my lord. Complaint case, my lord, I am a senior BSF officer. My lord, case is pending for the last more than 11 years. My lord, non-compliance of 202.
And now 202 after 11 years.
My lord, kindly cease. My lord, I am living in Punjab.
Sir, sexual harassment case.
No, not against me. No, my lord. My lord, he's a male, my lord. He was under me, my lord. After retirement, he lodges this complaint case. I had
Paragraph 5, you have written only. Your petitioner says that in the month of February and March, one Mary Tigga lodged a complaint of sexual harassment.
My lord, kindly cease, my lord. Paragraph 5, Mary Tigga lodged a complaint against the opposite party. And
then-
when he confronted with Mary Tigga along with her husband, he allegedly told that the complaint was lodged as per the direction of the superior officers. That is asked, my lord. All other accused persons, all other officers have been discharged. Only I am left, my lord.
Obviously.
Because my lord, he was under me. I had reviewed.
Same pay.
My lord, only a stay, my lord. In this.
Stay the one এখন petitioner is directed to serve a copy of the revisional application on the opposite party by speed post with AD and file affidavit of service on the next day 8 fixed hearing. Release the revisional application in the next available circuit bench. Petitioner would be at liberty to pray for entry aim order after a service upon the private opposite party is complete.
Oblige, my lord. Oblige.
नहीं
Lordship, I am for the,
I stated ही क्यों नहीं जो किया
I am for the revisionist. Lordship, motion still.
oh motions
Lordship, Lordship, besiege page 21
এটা খোলো খোলো দেখ কি আছে
from page 19.
order number 3 তে challenge করি
The VG was examined. Actually, the petitioner is Dr. Nayak, the co-owner of the hospital where the VG delivered a baby which later on died. Lordship, the VG was examined on Lordship, can you see page 19 on
no,
first
what is the impugned order? Impugned order is page order
impugned order, Lordship.
2/4/2025.
Lordship.
What is the where is that order?
Lordship, page 30. And certified copy is also there.
Please fix for appearance and all 10 exams will be present. Person name need to Nidin Nayak by say Shokanama we check. What is written over here?
Lordship, I could not find that. Lordship. I'm extremely sorry, but the handwriting.
Time person.
One petition was
File fresh wakalatnama along with time petition,
petition.
which is moved, heard, considered, and petition is rejected as witnesses are present and without they can't be without examination. They cannot be really as the honorable some direction regard CSW to in dock and examine in chief and prosecute in full and discharge. What is your grievance?
Lordship, kindly comes to page 21. The VG was examined in cross-examination, first line, cross-examination for accused Nitin Nayak declined by the lawyer. On the next day, the lawyer was changed and the new lawyer came and he gave a petition that I want to cross-examine because the previous,
Where is the
the petition is, Lordship, at page 27, page 27, Lordship. New Vokatnama and the lawyer is not handing over the documents.
That due to non-availability of certain important documents. It's a time petition, not a recalling.
I know that I was telling the same. Lordship, PW2 was there.
You filed 311 and come, I can
Same
consider.
thing,
This I will not
it was same thing I told.
চলো এটা হয়নি যেটা হয় না সেটা কি করে দেবো
Lordship, may I not press the same and that will be better. File a petition, আমি কালকে বললাম তো।
ইন্টারভিউ না করে কি
না।
আচ্ছা, learned advocate appearing for the petitioner has approached the court as on the earlier occasion, the present petitioner was not allowed to cross-examine the victim. Not allowed. The learned lawyer representing the petitioner did not decline to cross-examine the victim, and subsequently a new lawyer was engaged. Acha, full stop. The new lawyer so engaged prayed for time on the grounds that he has not received the documents. Full stop. Learned advocate appearing for the petitioner submits that the revisional application was preferred. However, the petitioner intends to prefer an application under section 311 of the Code of Criminal Procedure. Be that as it may, if so advised, the petitioner would be at liberty to file the same.
Deeply obliged.
Learned magistrate, learned special court would consider the same in accordance.
Grateful, Lordship.
With the aforesaid observation, this will be better.
Lordship.
So with the aforesaid observation, CRR 286 of 2025 is just.
Grateful, Lordship.
এটা ঢুকিয়ে দেবো, হ্যাঁ আবার কি এটা কাউকে স্টেটের একটা দিয়ে দিই, কেউ এটা দাঁড়িয়ে যাবে। Mr. Bhattacharya, acha, petitioner is directed to hand over a copy of the revisional application on Mr. Bhattacharya, who ordinarily appears on behalf of the state. His appearance may be irregularized by the concerned authorities.
Deeply obliged, Lordship. That will serve.
30. Give your name, sir. Mr. Bhattacharya, give your name.
Yes.
In the earlier matter.
Yes.
Acha, none appears for the petitioner or revision, nahi? None appears for the petitioner. Please the revisional application into the next available circuit. Next.
Lordship, paying for next circuit.
Which one?
30, Lordship.
30, 31. Vote in.
31, my lord, I am for the petitioner.
Yes,
Please, your lordship, my lord.
your revision.
Yes, my lord. My lord, the de facto complainant, my lord, case is under SCST. Case is under SCST Act. My lord, the de facto complainant, my lord, alleged that, my lord, I have,
What are you wanting?
my lord, at present I am wanting a stay on the warrant of arrest. Warrant of arrest.
করতে পারবো না, অ্যাপিল করতে হবে তো 14তে অ্যাপিল করতে হবে, রিভিশন লাইক করে না, any order.
My lord, not on that, I am on the, my lord, I have challenged the entire.
Whatever you have wanted, sir, you've got to do a appeal, otherwise only service order I will give. Challenge of any order, finding sentence.
My lord, since I have challenged the entire order,
then
sorry, entire proceedings.
Then no interim order. If you challenge an order, warrant is an order. That will
My lord,
come
no
after.
coercive steps, my lord, can be.
Keep
My lord,
up.
kindly then, my lord, at least allow me to place, my lord, 30 seconds.
No, but the thing is that then only service order, I'm telling you. Your interim order for stay of the warrant of arrest can be passed in appeal 14. Want to file it, tomorrow I'll take it up then. 2 minutes take aaj.
My lord, tomorrow then.
No, হবে না, certified copy return করতে হবে না।
My lord, certified copy. Oh, okay.
It's long procedure. I have got to
Lord, at least some, because
Do it before the next available, conscious not permitting, sir. Procedural part, I am not going to compromise. Any scope I usually grant, but see, appeal lies. Now, if you want a service direction, that I can give, but interim order I will not give. And that will not serve your purpose. Next, do it in the next circuit. Not. কিছু করার নেই, আমি চ্যালেঞ্জ চিন্তা ভাবনা করে করতে হবে তো। Advocate 8 appears on behalf of the petitioner. Advocate of the petitioner and the state is present. However, in view of the prayers advance, needs the revisional application before the next available circuit bench. Okay.
I am appealing.
Yes. Have you got a case diary?
Yes, ma'am.
Original case diary you have got?
Yes, ma'am, original city.
Huh?
Yes, ma'am.
What is the difference between the original case diary and the case diary which was produced before this court? There must be some difference. If there is no difference, then I'll work out on that, sir. When I've called.
Page number, I mean, certified city.
Third need to
All
be-
handwritten lordship and that was Xerox. It's all handwritten.
Yes, yeah. You want to do or you don't want to do? No Passover today, madam. Then next sir. Huh? Next sir কি তো আজকে টাইমই নেই এত মামলা 90টা 100টা করে মামলা ফাইল করবে তারপরে আমাকে এই করতে হবে। Learned advocate 8 for the petitioner prays for an accommodation. Learned advocate for the state submits pursuant to the direction passed by the AA's court. Original case diary has been produced. Let the original case diary be returned to the investigating agency. Matter be listed before the next available circuit bench. Accommodation বললাম না petitioner prays for চলো next. Learned advocate for the petitioner is present.
Well, at item 33, well, I'm,
Yes.
Lordship, I'm
Well,
for the state.
well, this is a case praying for
69. 164
a
is
love
there.
affair which has gone wrong. Both of us are in 30s.
Page
69.
20, Lordship.
Well, relationship since 2021, and thereafter I discontinued the relationship. Hence, the
আমার মা মারা যায়
application. The complainant is also a learned lawyer.
You are working in the army? Both of you can't argue, sir.
My lord.
Army?
My lord, I'm a major in the army, presently posted in Pune cantonment.
It is short of service.
What is the age of this lady?
She is presently 30.
Lordship,
30
13.
though, and at that time, 2018. She was able to understand the consequences of that.
Lordship, medical is in page 14, Lordship.
I'm not interested here. Whatever she was doing, she was not even in the tender border area of 18 to 20. She was around 25 years of age. Let us presume this. Today she is she is 29 years when the statement was recorded. That is date to that.
Lordship, WhatsApp chats are
25.
there.
Hmm?
Lordship, WhatsApp chats are there, Lordship, from page
No,
30.
no, I'm not saying offense. Now we are considering regarding the custodial detention of the petitioner. Petitioner is an army officer, number one. Number two is that the relationship continued for 6-7 years. 2018 relationship. Case registered on or about April 2025. So at the relevant point of time, she was 23 to 24 years old, this lady. So she was able to understand the consequences of her act.
Yes, Lordship.
Except promise to marry. Are there anything else? Providing job, promotion. Now within 69, everything is included. You
No, no.
understand? Earlier only promise to marry was there. Only marriage proposal.
Yes, Lordship.
ডায়মন্ড ইয়ারিং টিং নিয়েছে তো চলে আস learned advocate appearing for the petitioner submits that the petitioner is working in the army and has been implicated in connection with the incident case at the behest of the de facto complainant. Full stop. It has been submitted that even if the accusations made are considered to be true, the CAM do not warrant any custodial detention, as the de facto complaint was a major at the time of the incident and of such age that she was able to understand the consequences of her acts. Full stop. Learned advocate 8 for the state opposes the bill, produces the case diary, draws the attention of the court to the statement under section 164 of the 161 CRPC oblique 183 of the BNSS, as also the medical documents having regard to the period of relationship, the age of the de facto complainant, and the period for which age the relationship continued between the petitioner and the de facto complainant. I am of the view that at custodial detention in connection with the incident case is unwarranted. Accordingly, the prayer for anticipatory bail is allowed. Petitioner shall furnish bond of ₹20,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the arresting officer. If on bail, the petitioner shall. Where are you posted? Pune.
In Pune cantonment, my lord.
Ragraj. Once a month you meet with the investigating officer. The petitioner shall cooperate with the investigating officer, and once a week, once a month, meet with the investigating officer of the case till the submission of the charge sheet. Accordingly,
I'm grateful.
এটা allowed for the CRM A number 395 of 2025 is allowed. Chalo.
Grateful, my lord.
Who is for the state? What is your number? 61 না তাই একটু কি ফাস্ট ওভার দেওয়া হবে না বাবা, নট পসিবল। হ্যাঁ আর কি নেক্সট সাইকেলে করো, বসাক সাহেব আসছে করে দেবে তো লানে অ্যাডভোকেট হেল্পিং আর tomorrow no, tomorrow already 15 to 20 matters I have fixed. Only extension of interim order tomorrow. Every matter is small, sir, for me. Big, small, no difference. Then the advocate for the petitioner is present. However, state has paid for an accommodation. Accordingly, he lists the অনেক তো মামলা হলো তো এই সার্কিটে, হ্যাঁ, accordingly list the bail application, according to this the application for before the next available circuit bench. Next, 30 the 35 ওইটাই মানেই হচ্ছে নেক্সট সার্কিট চাইছে। ল্যান্ডের অ্যাডভোকেট শর্ট কথা কোন ল্যান্ডের অ্যাডভোকেট এড ফর দ্য স্টেট petitioner pays for an accommodation. You are for the state, Mr. Chakraborty.
No, I'm not.
None appears for the state.
None appears. The state is there, Mr.
Huh?
Mr. Misra is there, Subhash is not. State is there, my lord.
কোথায়? যাই হোক কিছু দিতে হবে না। আর ওই লাইনে accommodation, ওই লাইনে অ্যাডভোকেট কিছু দিতে হবে না, কেউ নেই সামনে কোথা থেকে দেবো। List the accordingly list the application with the next available circuit bench. Next. Yes.
I'm for the state, man. You have submitted in documents, Indian documents?
No, you help crossing the border, Dalal. Help crossing your allegation. তাই তো হয়, আর কি হবে? You are Indian who helps crossing the border. That is the accusation against you. That is, no, a statement of the co-accused will be there only. At the stage of investigation, sir. This is you help, this is the A. But this case was started on the basis of what?
One,
After interception only.
two Bangladeshis was intercepted.
Learned advocate. বর্ডার ক্রস করে দিচ্ছে সেই লোককে দিয়ে দেবো, এখানে এত চলছে ইনভেস্টিগেশন, এখন তো দেওয়াই যাবে না। হ্যাঁ, অন্য বছরে দেওয়া যাবে, এই বছর দেওয়াই যাবে। মাথা খারাপ নাকি? আমার চাকরি চলে যাবে। Learned appearing for the petitioner. Submit is that the petitioner is an Indian who has been implicated in connection with the and case on the basis of statement of the co-accused, full stop. Mr. Chakraborty appears on behalf of the state and produces the case diary. I find the accusations against the petitioner is that he aids and abets and also abates and also helps people for crossing the border. Having regard to the gravity of the accusations presently available in the case diary, I'm not inclined to allow the prayer for anticipatory bail. Accordingly, CRMA 402 of 2025 is dismissed. Next. Ready? Chalo. 64 against whom? You are who?
I am a husband of the complainant. So the allegations that has been made, it has been.
64 against whom?
Me, Lord, I am the husband. We are some language. Also, kindly see the affair, Lord, it has been already bigger from this.
Well,
I have been married due to 5 years of love and affection with the Lord complainant. After which, Lord, in spite of that, I will come to that point. Thereafter, Lord, both were the defense, the accused petitioner was already been married, and after which her wife was missing. After which, Lord, for more than 7 years. After which, the same facts and circumstances was been also been new to the complainant. And Lordship, the complainant also knew the very fact that the accused petitioner has also decided. Lordship, kindly appreciate the.
FIR to দেখি। No, FIR 1 minute.
After leaving,
Just 1 minute. I'll see the answer. After how many years?
After 7 years.
No, this lady.
This lady.
Yeah. Present lady.
The present complaint was they they meet Lordship in 2004, 2024. After which Lordship they agreed, both agreed to marry each other. After which the marriage was solemnized because it's by way of Hindu and religion. The woman also has his daughter. He was also married to his spouse who has died early. After which Lordship, by living as both are Lordship independent, they agreed to lead their constitutional life as by way of leading to the new marriage. But subsequently, what happened, Lordship?
That in the month of.
This lady, after knowing all the facts, are inclined to be on the second page. So kindly appreciate my.
Came in my house and since that we started.
She knew all the facts.
You have a son and a wife.
I have, it is a kind of very fine, I want to, my annexure. And they also manage the annexure.
Are you divorced?
No. My wife has been missing since.
No, that's an absurd. Missing means a strategic missing. Are you could have gone. If you know the police station, you will know the court also. Simple thing. And you can easily apply for divorce. You have defrauded in this marriage.
This is why I have not been recorded. And it's in my petition also, once noted annexure, he pays not anyone. And the conversation was made before the marriage, the conversation was made between me, I was the, there was marriage was made between law and ethics. And the complainant and me, that has been shown in case number 21 of the lawsuit. She knew. And it's a
What annexure is what?
Okay. The,
And WhatsApp chat is.
I have also posted, stated my picture of my child also to her lordship. Viewing lordship, all the things, the marriage was solemnized. My only thing lordship, the only fact lordship, she has suppressed that I have not informed him that I have already had. If the thing has been informed, come to the marriage was civilized. But if I have one child, me and my
Sir, once you decide that the law of the country will work according to your whims, that is what you are doing. Yeah, I am married. I have got a son. I will again marry. I will again demand dowry.
If I would have been, if lordship, there was no consent, once it was taken by fraud, there was a consensual relationship between the complainant and.
You have done everything, sir. One, you have taken dowry. Two, you have demanded further dowry. Three, you have suppressed your earlier marriage. Four, you are now throwing her away. Bas.
I could not go before a lordship of that, but what has been actually the conversation made between the complainant has been told by your messenger. Nowadays, lordship is, what is lordship as a conversation?
That after custody, you give it to the investigating. You give, had this been in evidence produced in a court by the prosecution, you accepted this evidence. You would have accepted the messenger in evidence. Then what is it you?
My is to produce the most convincing state of the statement which I have now lost.
No, whatever it is that is up to you. Your client has told you have given that you have placed your. Whatever it is there, sir, you have basically deceived and cunning.
I appreciate the other matters, but kindly have to oversee.
The application of the section subsequently. You first.
Fraud has been made. I have shown my photo also. Kindly appreciate.
Sure. Learned advocate appearing for the petition of. So my son, do you care for your child and your wife? You care how many wives and child you will care?
My wife didn't
Ah.
the fact of the husband is my wife, but the kind of report, my wife driven away from me.
That documentation you scrupulously you have done each and every time. You have scrupulously made missing diary. You don't did neither you filed any case for restitution of conjugal rights, nor you file any.
If I find the address, I will absolutely. But missing diary is how could I find it? He already ran away with the other person. Now, more than 5 years was evidence of that.
If we after you had the address of the your matrimonial home specifically, you didn't have the address, no?
No, I don't have the address. And also kindly appreciate that the complainant is the matured lady. And that after I have to take care of what she was living with my son lordship. But kindly appreciate in spite of that lordship.
The learned advocate appearing for the petitioner submit that the petitioner is innocent of the charges. Appreciated, considered, rejected. Learned advocate appearing for the petitioner submit that the petitioner married the married the de facto complainant. married the de facto complainant and it was out of love and affection. The say a marriage took place. The allegations regarding demand of dowry, as also the suppression of earlier marriage are afterthought. Full stop. Additionally, the allegations relating to further demand of dowry are also embellished for or building up a case. According to the learned advocate, there are digital evidence is to substantiate the case of the petitioner. Having as a learned advocate for the state, on the other hand, opposite is the prayer for anticipatory bill and submits that there are materials, particularly there has been suppression in respect of the first marriage, and so far as the present, so far as the de facto complaint is concerned, she has been deprived and thrown out, and the same is during the subsistence of the first marriage. Full stop. I have considered the material also on record, as has been in place by the state, as well as the learning, as well as the submissions of the learning advocate appearing for the de facto complaint. Having regard to the fact, I am of the view that the police authority is required to unearth whether the initial tie between the first wife and the present petitioner has been snapped. First wife and the petitioner has been snapped prior to the marriage with the present de facto complainant. Having regard to the same, I am of the view that the applicability of the sections in the case at the stage are of no consequence, since custodial interrogation of the petitioner is warranted. Accordingly, prayer for accordingly, CRMA 404 of 2025 is dismissed. Chalo.
I'm for the state.
Case diary is there.
Yes, Lordship, case diary is there, Lordship. Government wasteland. And the entire, the BLRO has clearly stated that the mutation was falsely done by some officials, and that those persons have to be identified for this custodial detention is required.
How is this person responsible?
Actually, this Umesh Chetri sold this land. Sold this land to
Umesh purchased from whom?
No, Umesh Chetri actually prepared a forged deed, and then forged Khotian, and then sold it to complainant.
So that I understand, but no government officer statement has been recorded.
Yes. Government officer statement record.
Recorded?
Yes.
What?
BLRO. BLRO statement was
Issue accordingly.
BLRO furnished a report.
Report on the basis of your requisition.
May I be permitted to read the report?
No, your requisition you read. What did you ask the BLRO to clarify?
The requisition was whether the sale deed, white number such and such, is valid or not, including the documents of the land submitted by the vendor Umesh Chetri at the time of registration of the land. Second question was whether the Khotian number such and such in respect of plot number such and such was issued in favor of Umesh Chetri or not. If issued, how government land was recorded in a private name. Was the Khotian number such and such in respect
of... What is the answer?
The answer is with reference to the subject above, this is to inform you it is a government wasteland. The land under Khotian number 1 record in favor of government of West Bengal, according of the office computerized land record, no trace of Khotian number Ato Mouja a copy of plot information is attached for your perusal. And subsequently, another report was furnished. In connection, the above mentioned subject enclosed here is the copy of plot information. LR plot 283 with an area of 0.12 acres. LR plot number 285 with
Just
an
one
area
minute, one. Eli plot number?
283 with an area of 0.12 acres. LR plot number 285 with an area of 0.50 acres are vested in the state in the year 2017 and are recorded in favor of government of West Bengal. Further, the undersigned does not have the authority to verify the veracity of any deed.
Very good. That is all right. Now 2017 is the date. What is written in the forged deed, to which year did he purchase? Umesh?
2015.
Then subsequently you have vested.
No, Lordship, not subsequent vesting. It actually what is happening in the true picture of the VLR office, they somehow actually there is a fixing between some clerks. This
I'm not bothered with that. Is matter of evidence you produce and prove one case, we'll see. No cases are being proved. My question is simple. Umesh purchased this in 2015. Vesting was in 2017. Any notice served upon Umesh?
Yes, notice served upon Umesh.
For vesting?
No.
For vesting? I mean,
not for vesting.
How will Umesh know?
Previously it was vested.
You said 2017 now.
No. From 2017 he is getting the information of the from 2017. The VLLRO. Actually, the government land was vested previously. It was from very previous. It was government land. He prepared a forged khotiar.
So where is this property? Riverbed or what?
No. Pradhannagar.
This is Riverbed. Where is the property? Marketplace, Riverbed. What is it?
No, sir.
কি আছে?
Shalbari Bazaar market.
Shalbari Bazaar. So that's at the heart of the city.
Heart of the city.
So which year it was acquired by the government? Vesting took place. You don't have record.
Investigation is on, Lordship.
Investigation first time not done. Heart of the city, the document must be available.
I will collect it, Lordship.
Collect it, please collect it. I see, sending a person to custody is
No.
not a glorious affair.
No, not a glorious. Liberty is very precious. I understand.
So you collect, you may build up a case that at least you have the document that, because if the case of the defense is that 2015 a person purchased property and sold it subsequently, and 2017 the vesting took place, now prima facie they seems to be innocent. But if you have a case to show 1990 notice was served upon the previous owner, these things must be there in the case, right?
Must be. Lordship,
keeping it in the next circuit.
Keeping it in the next circuit.
Investigate. Let him investigate. Position is not very important. Position everywhere in this part of the state is. No, I can't allow the same because if the forgery has taken place, it's a serious offense. And that is why to the hilt I am pressurizing him.
Yes.
Otherwise, I could have easily ignored and rejected that. Or I could have allowed that. But I am trying to find it out from the hilt in which year.
Lordship rightly pointed out this is the position of law. This is the position of law when the vesting was done, whether the notice was served or not. This is the point. If the notice was served, then the malafide is on the part of the
go slow.
Go slow. We'll go slow.
You collect the materials, thereafter take a decision. Collect that materials and thereafter take a decision. Till that time, you go slow. Collect the materials. I'm not passing any order.
Okay.
But you should have that material before arresting the person.
Obviously. If we get that material, then only we'll go for arrest. Otherwise, not.
This will against you. Arrest, I cannot. If I say arrest, they will arrest you. I am telling you. The learned advocate for the petitioner submit that the petitioners have been falsely implicated in connection with the incident case, and the petitioner number 1 happens to be owner of the land, and petition number 2. Petition number 2 is a witness to the deed conveyance. was a witness to the conveyance of the A title deed. Full stop. However, learned advocate for the state submits that the property oblique land in question is a West land, which on the basis of a manufactured document was sold by the petitioner number 1, full stop. I have perused the case diary and I find that the investigation of the case is in progress. The investigating officer is trying to collect the materials, but a case has been made out for the present that in 2015, the property was purchased by the petitioner number 1. And according to the state, wasting took place in the year 2017. The notice is issued upon the petitioner number 1 are yet to be collected by the investigating officer, as also the date on which originally vesting took place. In view of the aforesaid, at this stage, the investigation is required to be elaborately taken up with the land authorities. Acha. As such, let the investigation of the case continue. Petitioner, let them meet with the investigating officer. Let the petitioner meet with the investigating officer once in a week. Petitioner number 1, basically. Petitioner number 1 meet with the investigating officer once in a week. However, the investigating officer will not arrest the petitioner till the document referred to above is collected. I'm giving you petition number 1. Petition number 2 is not required. List the application for anticipatory bail. How much time do you require? Next circuit I'm giving
30 days.
Not next circuit.
Not next circuit.
List July থেকে একটা সার্কিট হচ্ছে না। Fourth week of July or 3rd week of July? 3rd or 4th week of July?
4th week of July.
List the application for anticipatory bail before the available circuit bench in the 4th week of July 2025.
De facto complaint purchased the land. De facto complaint purchased the land from the accused person.
In 2015.
De facto
complaint.
Petition number 1.
Put a petition number 1 purchase of the de facto complaint purchase from the petition number 1. যেখানে petition number 1 আছে। ঠিক আছে, next 39 বলুন। Learned advocate for the petitioner is present. Learned advocate for the stay aid pays for an accommodation. As such, let the application appear before the next available circuit bench. Next.
I am for the state. Lordship actually, yesterday asked for only on one point. Actually, it is a the patella was injured. That is the knee joint. Whether the statement of the victim has been recorded or not, no, it has not been recorded till to date.
When the incident took place?
No, there is a delay. There is a delay, but he was in a hospital for 10 days.
From which date to which date?
The FIR was lodged on 26.
Not bothered about the FIR.
Incident.
Tell me, FIR is of 26/5/2025. Medical reports.
Do we charge the incident is of 2/4/2025 and the medical report on the same? Medical report on the same day.
2000, 1 day. 1 day he was in hospital.
10 days.
So when was he discharged? Medical report of the same day means?
The presentation to the account.
That knee injury is of 2/4/2025.
Yes,
Huh?
yes. From the date of incident, 10 days. He was in the case died. Page of the case died.
So the 172 are the
172.
medical report you show me.
Medical report. Page 50.
All right, I'm keeping it in the next, record the statement of the injured.
Record the statement of the excellent.
I'm protecting you in the meantime. चलो चले আসুন চলে আসুন আচ্ছা ভাই although acha learned advocate for the petitioner submit that the petitioner is innocent of the charges and has been falsely implicated in connection with the incident case. She also the petitioner also contends that there has been delay of 44 days in initiating the present FIR. Learned advocate for the state on the other hand producer is the medical document. However, the statement of the however, the statement of the injured victim till day 8 has not been recorded by the investigating officer of the case. Having considered the same, I direct the investigating agency to take steps properly for recording the statement of the injured. In the meantime, no coercive measures be taken against the petitioner. However, the application for anticipatory bail will be considered independently after the statement of the injured is recorded. Because list the application before the next available circuit bench. Chalo na. Okay, nothing will be done to him. Until Umesh is arrested, how this person will be arrested? যাকে দরকার কি আছে না 10 মিনিট পরে
Made by
My lord,
Mr.
I am for the petition.
He's appearing for
If
it.
there he has
My
come,
lord, the unfortunate thing is that yesterday night, my lord, the petitioner has been arrested
petitioner
during
arrested.
during pendency, my lord. My lord, this is, my lord,
Learned advocate appearing for the petitioner submit aids that during pendency of the application for anticipatory bail, the petitioner has been arrested. As such, the application has become infructuous. Learned advocate for the statement of co-accused.
my lord, statement of co-accused. My one building is constructed by me. I was residing elsewhere. From there, septic tank, under construction building, 2 miscreants trespassed and stored some contraband. I have been implicated.
In view of the aforesaid 8 CRMA 410 of 2025 is dismissed as infructuous. Learned aid special court will consider the application for bail of the petitioner independent of any observations made by this court while disposing of this application for anticipatory bail. According to
Deeply
CRMA,
obvious.
CRMA next is subject. 10 মিনিট পরে
My lord, I am appearing for the petition.
Who is for the state? Learned advocate for the petitioner is present, none appears for the state. List the application before the next available circuit bench. Next.
But I'm for the petitioner, nothing has been recovered from the
Who is no
position of the
and no case there is there.
charge sheet submitted, my lord.
Nothing, my friend, so simply move the application. He is the mastermind.
But as per.
And
Finally see what is my.
total 832 kilos of gaja, my lord. Next,
অনেক বড়
Oh,
পরে সার্কিটে দেখবে বেকার
and moreover, they wait for the charge sheet. When the charge sheet is filed, they
No,
come
no,
with an
no,
application.
nothing
for
else.
accident.
next cycle learned advocate
This
for the
petitioner should be
petitioner is
taken
present.
tested.
Petitioner as well as the state is present.
এতগুলো বেল হয়ে গেল তখন তুমি বললাম আমার বেলায় বলো
না না কি বললো না বললো আমার কিছু এসে যায় না। হ্যাঁ
No, my lord.
আমি ঠিক বার করে নিতে পারবো, এইটুকু কনফিডেন্স আমার আছে। ও ডাক্তার সিম্পল লিখলেও আমি মানি না, আর ডাক্তার সেক্সুয়াল অ্যাসাল্ট বললেও আমি মানি না।
But if in the meantime petitioner was arrested, my application is infractual.
That is the law of the
That
land.
is our difficulty.
Law of the land. List the application before the next.
The CD before the court.
44. কে আছে? কেউ নেই? 44 you are not there. 44 who is there?
I am happy.
Learned advocate for the next circuit. Learned advocate for the petitioner and the state is present. List the application before next available circuit. Next.
Your lordship. I'm for the petitioner, your lordship.
Don't want to do.
Lordship, it's
Next
a humble,
circuit.
no, sir, lordship, kindly fix the matter tomorrow, your lordship.
Tomorrow no fixation. You need.
Lordship, already my one matter has been fixed for next circuit. It's a humble request, your lordship.
Where is your brief?
It's there.
The briefing is learned advocate aid for the petitioner and the state is present. No, 43.
No, no, what's it?
45 you are appearing.
No, my lord, 46.
However, the case diary is not available. For the list the application your next available circuit means next.
I'm on behalf of the petitioner.
I am appearing.
My lords, I appear for the legal LR of the complainant, my lords, de facto complainant.
Under which section?
My lords, pursuant to my lords,
My lord, I was granted an anticipatory bail in this case, my lord. It
Ah.
is in page number 11, my lord.
Thereafter,
And thereafter, charge sheet, they were condition were waived. And my lord, the charge sheet submitted, my lord. Thereafter, the de facto, the sister of the petitioner, my lord, filed after the death of the de facto complainant. The de facto complainant is dead. Thereafter, the sister filed a re-investigation prayer before the trial court, my lord, for the ACJM Jalpaiguri, my lord, which was allowed, my lord. After which, my lord, the IO of this case, my lord, has given an application for cancellation of bail, which is in page number 28. So
My
I
lord,
am
this
anticipating
application
arrest
is
at the
not
present moment,
maintainable.
my lord. And therefore, my lord, I have filed this anticipatory bail.
why warrant is pending?
No, nothing.
my lords, this is
I
not
I got a judgment, my lord.
Then how can this maintain it?
My lord,
No,
this
this
is
is
a
not
judgment, that is
maintainable.
why. My lord, kindly see, my lord, kindly.
Pending before whom?
The cancellation of bail application
Huh?
before ACJM, my lord.
So how can I interfere now?
My lord, there is a judgment, that is why I filed this case, my
তাহলে
lord.
কিন্তু judgment দিয়ে উঠে
না,
দিয়ে
একটু
দিয়েছিলেন।
দেখুন না।
My lords, I have a
My
Supreme
lord,
Court
kindly don't
judgment,
do
my
that,
lords,
my
on
lord.
this.
Please, my lord,
My lords, there's a
please, my lord.
Supreme Court judgment clearly
My
saying
lord.
not
Not
maintainable.
applicable, sir.
But if it is not applicable, then you kindly say that only it is not
No,
applicable.
then I'll reject the matter. If I go through the matter,
My lord, don't do that now, my
No,
lord.
no.
I am confused, my lord. Kindly see once,
do
my
it in
lord.
the next
My
circuit.
lord, you see once,
Convince the next circuit.
Once only
My lords,
once.
Conceptually, this
My
is
lord,
not
my lord,
correct.
kindly, my
My
lord.
lords-
That's why, my lord. My lord,
My
I
lords,
saw
can
you,
I-
my lord. I filed this case, my lord, because I was confused, my lord. Kindly see, my lord.
Next circuit.
My lord, kindly, my lord. Kindly, my lord.
হবে না কিন্তু বলে দিচ্ছি আমি, লাই করে না।
লাই করে
My
না
lords-
তো। কিন্তু আমার এই জাজমেন্টটা
জাজমেন্ট আমাদের কাছে কোনো ব্যাপার নয়। এখানে
My lords, can I, my lords, can I just show, my lords,
জানেন অ্যাডভোকেট
my lord, don't do that now, my lord.
করে দেবো।
My lord, you kindly see once this judgment, my lord,
Do
that
it in
there
the
are.
next circuit, madam. Don't do it. I'm telling you. It's not an application which is maintainable. Once the process is completed, we'll go from the original one, from good boxing CBI will start.
my
My
lords,
lord,
there
this
is,
is a
in
judgment
fact,
which says that if there is a cancellation of bail application, my lord, and if I participate in that, then I cannot file an anticipatory bail application. That is why I filed.
So you cannot participate. And why have you filed the anticipatory bail application? You were earlier granted anticipatory bail.
Yes.
Huh? So cancellation is a right of the de facto complainant for subsequent change of circumstances.
But there is no change in circumstances.
That
There
is
is.
your contention.
My
And now I have got to go into that.
My lord,
If I go into that, because they will be definitely submitting something, they will not be going by what you say.
my lord,
They are appearing for, or the other side, they'll be saying something.
my lord.
So naturally, how can a right of cancellation of the de facto complaint of the state be taken away?
No, my lord, I'm praying for anticipatory bail in that case only, my lord. That
How
if-
can you pray? This is overriding a court's jurisdiction. ACJM is considering an application for cancellation of bail.
My lord.
You are apprehending arrest.
Yes, my
And
lord.
no order has been passed till now.
No, my lord.
So how can this application be maintainable? That's why I'm telling you.
It says that if I participate in cancellation of bail application, then I cannot file an anticipatory bail application.
You cannot.
Yes,
But
my
then
lord.
earlier you were granted anticipatory bail.
Lord.
So How can a second anticipatory bail in such circumstances lie?
It will not
Milords,
be.
can I say one word, Milords? Can
Go
I
to
say
the
one
next
word?
slide. Go to the next
Milords,
slide.
may direct them to serve me a copy.
Very true.
My lord, how can they be participating in this case, my
No,
lord?
no,
They are de facto
Milords, I
complainant, my
must be
lord.
heard.
They do not have any locus, my lord.
Of course, I have a locus, Milords. Kindly, Milords, direct them to serve me a copy.
Cancellation is at behest of whom?
At the police, my lord.
De facto complaint is an essay where you file an application for addition of party.
Milords, may direct, Milords, the law is clear. Jagjit Singh, Supreme Court says I have right to participate, Milords, at every stage.
Petitioner is directed to petitioner, learned advocate for the petitioner is present. A copy of the since an application for cancellation of bail is pending before the learned aid SCGM.
My lord.
Petitioner would serve a copy of the application upon the learned advocate appearing for the de facto complainant.
Milords, LR of de facto, because de facto has passed away. LR of de facto complainant, Milords.
Substitute. They did not file any substitution application also in the
No,
lower
no,
court.
Milords, I am.
That can also, victim definition has changed.
Yes, that LR includes, Milords. I am an LR.
He is also an LR, my lord. The petitioner hearing. He's the son and they are the daughter.
Legal representative of the de facto complainant.
Grateful, Milords.
Advocate appearing for the legal representative of the de facto complainant. তারপরে হচ্ছে ওই learned advocate of the state is present with the application before the next available circuit page. SCGM where? SCGM is of where?
Siliguri.
When?
Grateful, Milords.
Learned advocate for who is the petitioner? You are the petitioner. 47. He is 47. You are praying for next circuit, Mr. Chakraborty. Learned advocate for the petitioner is present. List the learned advocate for the state prays for an accommodation. List the application with next available circuit page next.
Your Lordship, I'm praying for next circuit.
Learned advocate for the petitioner is present. Petitioner in the state is present. List the as prayed for. List the
My lord,
application before the next.
I have just one prayer before your lordships. I have received the CD. Original, but subsequently I found some pages is missing from the original CD. It's very unfortunate.
Should I record?
I will record, my lord, I will give you explanations.
Learned advocate aid for the state submit that certain pages are missing in the original case diary. According to the investigating officer of the case will submit a report regarding the whereabouts of the documents which are not presently available in the case diary on the next day 8 when the application for anticipatory bail is taken up for hearing. Yes, yours is বিশ্বাসেরটা করে দিও দাঁড়িয়ে আছে বেশি এই 61টায় কে আছে মিস্টার বিশ্বাস who is your other side? Just 1 minute. 61টা একটু দিন না ও দাঁড়িয়ে আছে বেশি I got to step.
Grateful, Your Lordship.
Yes.
61, it should. 61.
Yes, Mr. Nag.
Yes.
What
This
is
is the
the
second
change of-
application, my lord. This is the
Second
second
application, what is the change of circumstance?
My lord, one of the accused persons has been granted bail, my lord. And another is the charge sheet has been submitted. The section of gang rape is not there in the charge sheet. This is the change.
My lord, this is the 164 statement of the.
But
No allegation of rape is there.
No, this statement was produced when the earlier application was considered.
Yes, yes, man. 164 statement was there, man. At the time of.
I cannot review the earlier court's order. Had this statement not been there, I would have definitely considered that.
Well, the change of circumstances is there. Now there is no gang rape, allegation of gang rape.
No,
In view of that,
without allegation, suppose this, but the statement was there before a coordinate bench. I cannot sit in appeal. এটা কবে রেকর্ড হয়েছে? ছিল ডেট দেয় না। This one 30th September, what, when was this recorded?
my lord, may
সপ্তমী তো ডেট দিবেন আমি এই সিট সার্টিফিকেশন
certificate is there, my lord, the second, next page.
There is absolutely no allegation of rape, my lord.
আরে দেন এভরিবডি ফ্ল্যাটগেট উইল বি ওপেন স্যার সুপ্রিম কোর্টেও যেতে হবে তো মাঝে মধ্যে
Kindly consider, my lord.
মাসুদ হকের নাম আছে তো
The name is there, my lord, but there is no allegation of rape, my lord.
আরে কি ব্ল্যাকমেইল করতো তো আছে তো
But blackmail could ultimately he couldn't avail.
No, but that cannot be considered now, sir. This, his name is appearing over there
That
for
is
some
it.
role.
That is
And
the
about-
one that the gang rape is removed from the charge sheet.
That may be, but this was considered, sir. This was considered. Now, what case is there? Charge sheet?
Charge sheet submitted, my lord.
Charge sheet billable offense নাকি?
No, no.
376 is there.
376 there.
হ্যাঁ?
Well, kindly consider.
চলে আসুন। Can be reviewing the order, which I don't want to do. 3-10, এই হয়েছে কবে? When was your earlier rejection?
20 January 2025.
তাহলে এটা ছিল তখন।
Well, may I try my luck before?
হ্যাঁ?
May
Next
I
circuit?
try luck before?
হ্যাঁ, next circuit? হ্যাঁ, এটা আগে বলুন যে সকালবেলা বলুন না বেরিয়ে। আমার যা কাজ করা হয়ে গেছে, আমার কোনো কাজ করার নেই। Then the advocate appearing for the petitioner. Prays for an accommodation. Then the advocate for the state has produced is ready with the original case diary. In view of the accommodation sought for, or let the application appear before the next available circuit bench. আর এই করে দাও একটু লিখে দাও original case diary be returned
Yes, sir.
to the investigating officer of the case. Also, pendency of the application will not deter the investigating officer from exhausting the process of law issued by the learned trial court. চলো ঘুরে আসি গুছিয়ে নিন আপনি একটু হ্যাঁ একটু টেনে নিতে হবে
My lord,
give me 5 minutes break I'm coming.
my lord.
My lord, item number 50. Oh, recess.
My lord, I beg of your pardon, your lordship, with regard to item number 32, my lord. The lordship was pleased to make the matter not today, my lord. And
Not
next,
today,
next circuit, not kindly take up the matter, my lord. Yesterday, my lord, kindly, my lord. My lord, yesterday, your lordship was pleased to direct the, my lord, the state to remain present the, my lord, the investigating officer. This is a political animosity matter, my lord. Mr. Bhattacharya is present, my lord.
I passed the order. I will not, because it will be very difficult. Already orders have been typed.
But I am the petitioner paying for next circuit.
Learned advocate for the petitioner, place for an accommodation, list the application, next available circuit will next.
In
Lord, I beg
item
to appear
number,
for the petitioner, my lord.
in item number 50, I am appearing on behalf of the DRI, that is respondent.
My lord, this is a matter where, my
Yes.
lord, the petitioner,
How we will produce the case diary?
That's why my humble submission is that, my lord, kindly fix it tomorrow, my lord.
Tomorrow not possible, sir.
Tomorrow.
Learned advocate 8 for the petitioner is present. Learned advocate for the Union of India praise for accommodation. Union of India oblique DRI go to the praise for accommodation. List the application before the next available circuit bench.
I'm so grateful, my lord.
Grateful.
My lord, I am for the petition, my lord. Recovery, my lord, 29 kg 494 gram, my lord. Custody near about 1 year, my lord. My lord, charge sheet submitted. There are 3 accused, my lord.
How many days in custody?
Near about 1 year, my lord. Near about 12 months, 26.
Stage of the case?
My charge sheet submitted.
Only charge sheet submitted.
Only charge sheet submitted.
যতক্ষণ না বেল হয় কিছু হবে না। Is how many kgs?
29 kg 494 gram, my lord. 29 kg, my lord.
Page, Caesar list.
My lord, in the FIR also, my lord. My lord. P1, my lord.
Page number.
Okay. 59. No, my lord. Page 9 is my written complaint, my lord. My lord.
Page 9, 29.494 kg.
Yes, my lord. 39 packets, my lord.
29.494 kg.
My lord, below 30 kg.
Just বেরিয়ে গেল আর কি করা যাবে, কিছু করার নেই। চলো learned advocate 8 for the petitioner submit that the petitioner is in custody is since 26th of June 2024. The investigation of the case has already been concluded. And according to the learned advocate, there has been no progress before the learned trial court. Learned advocate for the state produces the case diary and opposes the application of bail by submitting that commercial quantity of contraband of the Gaja is from the possession of the petitioner along with 8 others. Having in regard to the fact that the petitioner is in custody for more than 11 months and that there is no scope of the trial being concluded in the near future. I'm of the view that the petitioner may be released on bail on furnishing bond of rupees 20,000 with 2 sureties of like amount each, one of whom must be local to the satisfaction of the learned special court.
And Shiliguri, madam.
Special court under the NDPS Act, Shiliguri. Subject to the condition that the local surety in the present case would be of a person residing within the jurisdiction of the learned special court, Siliguri, and would furnish a title deed and would deposit the title deed of a property, which would be retained till the end of the trial. Full stop. In case is the petitioner in case the petitioner evades the process of law, the property would be forfeited. Okay, hello. The petitioner shall make himself available physically on each and every day of the trial, and shall not hinder the progress of the case. Full stop. With accordingly CRM NDPS number 106 of 2025.
Pradeep.
Yes. That's it. Yes.
Lordship, that's section 50 by.
Yes. Hmm.
At the time of incident, the was present, that's why it's. But the others forward is done properly at that moment. Section 50 notice was given by the ASI, search seizure arranged by the ASI and complaint.
Executive magistrate,
No, not present.
no gazetted officers, how section 50 is complied with? No, none was present. Do you have? That is not very important. What I am wanting is that, do you have a notification that ASI can do this?
Lordship, I have given the judgment of the court where it says.
No, but then these are remote places. If they have a notification, I have got to check that, sir.
They don't have, Lordship. I don't know.
Only tomorrow I'll take this matter. It will not suit anything.
This was the contention on the other earlier day.
Outpost hole tai hobe. But then section 50 must be done for a gazetted officer, sir. At least the inspector.
He has to take the accused to the gazetted officer.
Or the inspector of police is available. You can intercept the person, detain the person, but ASI cannot be the gazetted officer.
Dinhata PS, Lordship, the subdivision PS.
Subdivision means subdivision is a small place. Kothay remote place. You have got to give Mr. Chakraborty, you ask your DM that whether there is any notification that ASI can do at the remote places as an act of the gazetted officer under section 50. Because there are many remote places over here. May not be possible to organize a gazetted officer immediately, not even an inspector in charge. I don't know whether it is there. If it is not there, you just come up with that. If it is there, come up with that only on this, because section 50 usually cannot be done by ASI of police. Non-gazetted officer cannot do that. Or ASI, that's whether any form of power, in any form, any power has been given.
Yes, ASI there is power, but ASI.
But this is ASI.
Lordship, I have given the.
Inspector of police is SI gazetted.
No. Inspector.
From inspector.
Lordship, I have given the order where the notification is there, West Bengal government notification, that not below the rank of SI. Notification is mentioned not below the rank of SI.
Delegated power.
SI is very much capable to.
Yes, exactly. SI.
That's why I am taking.
SI section 50 cannot do.
Lordship, in West Bengal, SI can do section 50. That notification I have given, Lordship. I can give in.
The SI, if it has been delegated,
Special delegation order on government GO must be there.
There are certain outposts where those are remote places right now. That is why I asked.
Lordship, in Kolkata, the surgeons are empowered to do it. But in West Bengal police, no.
Inspector rank Kolkata police inspector from Gauke there. Kolkata police in OC is the inspector of police. This should be done in Siliguri Police Commissionerate also. Senior police officers must be OCs actually.
Lordship, Siliguri Police Commissioner, I have, they don't give. It is not there.
No, but minimum inspector of police, otherwise no use. Why is the commissionerate?
Right.
That because senior officers are monitoring a small zone. That is why a commissionerate is built, so that effectively things can be done. No use of giving same Bengal police will work in the same manner, that no use. Learned advocate, Mr. Chakraborty, learning aid, additional public prosecutor is directed aid to ascertain from the district magistrate as to whether there is any delegation of power to Assistant Sub-Inspector of Police in respect of NDPS Act for or compliance of the provisions of section 50 of the NDPS.
Section 42, because 50 says person empowered under 42.
And 40 and 42 of the NDPS Act. List the
42.
list the
43 वाला पढ़ 42 वाला पढ़
list the we calculate list the application on 20th June 2025 under the same individual.
deep level resolution.
My lord, I am appearing on behalf of the petitioner.
Yes.
My lord, the contraband, my lord, seized, alleged seized is 264 grams of brown sugar. The commercial quantity, my lord, it comes to 250 grams. My lord, I have an innocuous spread. My lord, let the charge sheet has not been submitted, investigation is going on. My lord, let the contraband be taken out of the polythene plastics and be weighed. So that I can take the ground of section 37. If it comes down below the commercial quantity, I will be entitled to bail and section 37 won't be a bar. Well, to the similar effect, I was party to a matter which Mr. Shorkar is there to assist your lordship with the orders. A similar matter was moved before this honorable court, before a coordinate bench in the year 2021, where similar orders were passed and it came down to below commercial quantity and the petitioner was enlarged on bail. If your lordship will kindly seize the order of this honorable court, it starts from 29/7/2021. It was 252 grams at that point of time. My lord, thereafter the directions were given by this honorable court to take out the contraband from the plastics, from the alleged purias and weigh it. Subsequently, the weight, it came below the commercial quantity and the petitioner was granted bail.
This is
My
not
lord,
Here is not
My lord?
267 grams. 264 grams.
No, but this is this is a different order. This is CFSL report. Where
yes, my lord.
Where is the
My lord, will kindly seize the first order 29/7/2021.
that have given.
The poly packets are concerned. The petitioner argues that if the weight of the paper in which the contraband was packed and the weight of the poly packets are considered, the
where
weight
was
of the
your
contraband will be
allowed?
less than 250 grams. Well, the
that
last
is
order.
That is this is your contention.
The last order. No. Subsequently, it was allowed in the first order.
Where was it
Subsequently, it
allowed?
was weighed before the learned magistrate.
Where was it
My lord, in
allowed,
the,
sir? I
the
don't get
second
that
order,
of allowing.
the
That is
order
not reflected over
dated
here.
My lord, there are three orders. Three orders dated 29/7/2021, 16/9/2021, and 28/9/2021. There are three orders given.
That is
sorry. Okay. ঠিক আছে।
So that was a borderline case. Is it? How did you weigh this with the plastic?
No, no,
boxes or in a?
It was weighed with the plastics.
packet.
Lordship will
This is a
kindly
packet.
comes
This is
to
plastic packet, but-
page 20.
but here is 264 gram, my lord. The plastic
How
weight-
many packets?
Two packets.
Two packets, my lord. Two packets.
Lordship will kindly comes to page 20.
No, this is not. That was a borderline.
My lord, page. That
my
was
lord. That was the
252.
borderline
This
case.
is
252
that was
grams.
252. This is
Yes, my lord.
264.
2 something
My
gram,
lord,
maybe the weight
My
of
lord,
the
may I
plastic.
say this? My lord, may I say this? May I
There
say
is, my
this?
lord,
My lord,
14
I am
grams
not
extra.
praying. I'm not
Here is only
praying
14
for
grams section.
bail at this
That is
stage.
not possible.
I'm not praying for bail at this stage. My lord, my lord, if your lordship passes an order to such effect, the investigation is continuing. Post charge sheet, I won't be able to take this ground.
Not already,
Let the actual contents be weighed.
already
Lordship will
samples
kindly
in,
comes to page
how
20.
can it be possible now?
Now, now page 20, if your lordships kindly sees the second last paragraph. One cuboid shape, 20 mm into 9 mm into 1 mm packet containing 139 grams to be brown sugar, which is wrapped with brown silver, marked with Exhibit A. And the second is also wrapped with brown sugar, which is wrapped.
CFSL report.
Let the contents, my lord, only 14 grams.
No, this is not the.
Only 14 grams. Only 14 grams.
14 is
Lordship
used.
will kindly allow this spray and keep it to the next circuit. Oh, no, only 14 grams. My lord, whatever it comes, I will be, my lord, let me take the chance because the investigation is not yet over. Let it be weighed. Let the
It's on the
actual
first day
contraband
this
be
we have
weighed.
taken
Yes,
out.
my lord. Already
Well,
sample collected, sample sent.
Well, now
CFSL
the
report collected
investigation
by the
is going
investigation
on.
agency. How can it be possible right now, my lord? At this stage, my lord.
First day you should have taken up
Yes,
this
my lord.
point, sir. Relative play.
My lord, the investigation is still continuing. This is only 264, only 14 grams of difference. My lord.
The learned advocate appearing for the petitioner submits that that the petitioner was in connection with the incident and case as they were seizures. To the tune of rupees.
My lord, may I say something? My lord, may I make a humble prayer? My lord?
254 grams.
But if your lordship is not inclined, my lord, can I then withdraw?
After completion of hearing, my lord.
264 grams of brown sugar. The contention of the petitioner is that there is every possibility of the same being exceeding because of the weight of the plastic packets. Learned advocate has placed order of CRA 3570 of 2021 to substantiate his contention. I have considered as a learned advocate for the state opposes the prayer for bail and submit that commercial quantity of contraband was seized in connection with the incident case from the possession of the petitioner. Having in regard to the fact that the case which has been relied upon by the petitioner was of marginally overweight, while in the present case 14 grams of brown sugar are there above commercial quantity. Learned advocate for the state has also submitted that the CFSL report has been collected in regard to the same. At the related stage, I am not inclined to accept the prayer of the petitioner. According to CRM indicates number 3 of 2025.
Obliged, my lord.
Grateful. Grateful.
On the basis of confessional statement, my lord.
Yes.
My lord, on the other, my lord, my lord had taken up this matter, my lord. My lord had asked them to show the ownership of the vehicle, my lord.
Lordship, there are
Is been filed পাচ্ছে না নাকি? মোতাহার হোসেন। Yes.
Lordship, the registered owner of the vehicle is the sister-in-law of this petitioner, Lordship. And thereafter 67 notice was I was trying to sub, but he was abscond, Lordship. And in this case, Lordship, from the CDL, Lordship, there is constant, they are touching their mobile phone.
Who were in touch?
This petitioner and other two accused person, they are arrested, Lordship. From their possession, 4,700 cup syrup, total cup syrup was recovered. And there are many bank transactions, Lordship.
Bank transactions?
Yes, bank transactions are there, my lord. That is obvious, my lord. They are family members. My lord, my lord, Sarfaraz Khan, from whom the contraband was recovered, my lord. My lord, the petitioner before your lordship is the brother-in-law, is the son-in-law of Sarfaraz Khan, my lord. That is obvious that there will be CDRs and bank transactions, my lord. But there is
Another accused person,
but my lord, there are no recovery. There is no recovery from.
The recovery, how? You were not there in the vehicle. How will the recovery?
My lord, they say, my lord, if kindly takes up, my lord, page 15, my lord, the seizure list, the car bearing number WP 73K043, which the FIR named accused Mohtar Hossain was left on the road to avoid arrest. My lord, how do they come to that conclusion, my lord?
My lord,
I am not the owner of the vehicle, my lord. I do not have, there was no contraband seized from my possession.
The question is that there is a statement to the effect.
That's only.
Mohtar Hossain was using the vehicle.
no, from the house of Mohtar Hossain, it was.
No, my lord.
No. The vehicle was left.
My lord, actually today morning, there was no pagination in this is a voluminous CD, my lord. I require some time.
Okay, 8 for the petitioner. Is present state place for an accommodation. Next second.
My lord, then grants me some protection, my lord. Till next second. No, grants me some protection, my lord. My lord, there is no recovery from me, my lord. Kindly appreciate, my lord.
This application will next.
কোথেকে বেরোলো এটা?
Chalo next.
ঠিক করে
সব দেখে Yes.
Well,
kindly appreciate the service, my lord.
Yes.
All are left for Delhi. For what, my lord? No one is present in the house of the victim.
Very good. Show me the medical and the 161.
Yes.
আর কি আছে এই কেসে?
It is in. Medical 28, 164, 27. In the envelope.
Section 4 and 18, my lord. Kindly see the allegation is attempt, my lord. 4 is there, my lord. 4 does not attract, my lord.
সে attempt করেছে।
Petitioner is the neighbor of the, my lord, de facto complainant, my lord. There is a dispute between the parties. For that is this case has been started. See what it is.
সবই দেখে নি 37 কি আছে?
Statement of grandmother.
তো what grandmother? কিছু করেনি, attempt এ case করেছে, আবার কি করবে? Trial face করবে। Learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated in connection with the case. And there are hardly any allegations so far as the substantial provisions under section 4 of the POCSO Act is concerned. Learned advocate for the state has produced a case diary as also referred to the one statement under section 1 of CRPC as well as the medical documents. I have considered the materials as well appearing in the case diary, and on an assessment of the same, I am of the that custodial interrogation of the petitioner may not be required in the factual circumstances of the case. Accordingly, the prayer for our anticipatory aid is allowed. Petitioner shall furnish a bond of যা আছে পুরোটা দিয়ে দেবে, 20,000 টাকা, দুটো 10,000 টাকা, একটা লোকাল দিয়ে দেবে, আর এই দিয়ে দেবে ওই 438 438 to 482, আর তারপরে হচ্ছে if on bail charge not submitted না, if on bail if না submitted, আচ্ছা petitioner shall shall make himself available physically on each and every day before the learned special court. Full stop. Petitioner shall leave the jurisdiction of Saibganj police station only after taking leave from the learned aid special court. Full stop. In case there is any violation of the condition, learned special court would cancel the bail without further reference. Cancel anticipatory bail. Cancel the bail. Cancel the bail subsequently granted if any. In case of non-compliance of the procedure without further reference to the court, this order of anticipatory bail will remain in force for a period of 6 weeks from date. Full stop. Report submit report submitted aid by the state, we get the report.
My lord, as per last my lord's direction, we were asked to procure from the date of is my lord,
who is for the state? For the state. Have you received the supplementary? Supplementary.
My lord, the last 2 pages would be relevant of the supplementary affidavit, the annexed one, my lord.
Yes.
I mean, the injuries
These are
were
the 3
simple.
persons before this court.
Yes, my lord.
The warrant of arrest has been issued against the 3 petitioners, namely in the naam diye debe. Other 32 accused persons were present before the learned aid ACJM Tufanganj. Having considered that the present case was registered in the year 2021 and earlier the petitioners were on bail.
Yes, ma'am.
And the warrant of arrest has been issued on 11/3/2025. I am of the view that the warrant of arrest so issued be kept in abeyance till 21st of July 2025. In case the petitioner appear before the learned aid trial court and were earlier on bail, they may be allowed to continue on the same bail and bond. However, in case the petitioner do not appear within the aforesaid time period as directed above, learned aid court would revive the earlier order and exhaust hardship process.
My lords, as your lordship may.
Accordingly, A CRM A number of 359 of 2025 is allowed for the. উপরে supplementary affidavit filed by the petitioner be kept with the record উপরে লিখে রেখে দেবে ঠিক আছে Yes.
Not 62, my lord, I'm for the petitioner. Affidavit টা কত?
You received the supplementary affidavit?
Yes. Lord, this is the supplementary, my lord.
Yes. Give it.
My lord, the finally takes up the supplementary affidavit itself. Lord, may I refresh your lordship's memory about the facts?
Yes.
My lord, in 2000, the complaint states that in 2017, the complainant was sold some certain property by this petitioner. Now, my lord, the fact remains that in 2016, a power of attorney, my lord, was executed by this petitioner in favor of one person with respect to the land measuring 43 decimals. Now, my lord, the complainant happens to be sold a property measuring 5 kathas. Now, my lord, will take up page 11 once of the petition, my lord.
You say part of the property?
Yes, this is the entire 43 decimals. This 5 kathas, which forms part of the complaint, that is one part. And, my lord, the allegation that he is making that Deepak Chetri is, my lord, encroaching upon his land and I have sold off land to Deepak Chetri, that is, my lord, a completely separate land. I'll show that to your lordship. That this essentially boils down to a boundary dispute, nothing else. There is no criminality, my lord. Sees the, my lord, page 11, the schedule of the property.
Deepak Chetri?
No, my lord, I am Manoj Sharma. I am the owner of the entire property, the original owner.
Very good. But what is his FIR is against Deepak Chetri is what?
Yes, my lord. Takes up the complaint.
Page 80, sorry, 80.
Page 9.
The page 8 is who? You are an accused, Deepak is also an accused.
Yes, but I am the original owner. Deepak Chetri is, my lord, the subsequent purchaser. And Deepak Chetri is the one who is encroaching upon the property of the complainant allegedly.
So you are the original owner?
Yes.
So you have sold the property to whom?
I have firstly sold a 5 kathas of land, which is different to, my lord.
No, to this Vinod Bhujel.
Yes. I have sold a 5 kathas to him. But those 5 kathas and the 5 kathas that Deepak Chetri is occupying are completely different plots of land. That is what I am showing to your lordship.
Just show me.
Yes, ma'am. Firstly, sees, my lord, the schedule of the property at page 11, which is the complaint. My lord is seeing page 11. My lord, this says recorded in Khotian number RS 422 LR 2615 appertaining to and forming part of plot numbers RS 29 LR 493. This is, my lord, LR 493. The boundaries are, my lord, important. North says 18 feet Kacha Road, south land and house of Aita Maya Rani, east sold land of Tika Prasad Sharma, and west land of Kaushalya Muktan. Now, my lord, sees the supplementary affidavit once. Yes. The supplementary affidavit at page 23.
Yes.
Page 23 of the supplementary affidavit, this is the land of Deepak Chetri. All that pigeon parcel of 5 kathas, my lord, will see the LR plot numbers 493 and 494. In the schedule of the complaint, it is only LR 493. This 5 kathas forms part of 493 as well as 494. Now, my lord, sees the boundary thereafter. Boundary says 16 feet wide Kacha Road, tallies this with the complaint. Same, north is same. South is Dhruvo Prasad Pradhan. East is, my lord, land of Tika Prasad Sharma, which is again common. So essentially, my lord, 2 boundaries, north and east, are common, but my lord, south and west are different. So this essentially implies that these are 2 adjacent properties with 2 common boundaries, but 2 different boundaries. So these are not, my lord, the same properties. They are adjacent to each other, maybe a little far from each other, but not the same plots of land. So essentially, there is a boundary dispute.
Yes, state.
No, my lord, both are the same piece of land. So, they just right now the boundary is different, but the land is same.
Land would be same, because he says 43 decimals, out of that 5 katas have been sold.
Yes, my lord, but from the same position.
Same 5 katas.
Yes.
How can that be, my lord?
The plot is same. Kindly see, lordship, the LR plot number, that is 493.
Yes.
And lordship, this is my deed which Manoj Upadhyay has sold me in the year 2017. Lordship, he has executed a power of attorney in favor of Rajat Singarve in 2016. And then in the year 2017, he has sold me that plot of land. And I was enjoying the possession in that land. And I have built a small room. And then
Yes.
now, this Rajat Singarve, in the year 2019, he has, through the virtue of this power of attorney, he has sold that land to Deepak Chhetri. And now he is encroaching in my land. The plots are same, your lordship. And he has illegally obtained electricity line in that plot of land.
My lord, I'm again drawing your lordship's attention to the 2 plots of land.
You have a civil suit. You have a civil suit, injunction is there.
Lordship, civil suit has been filed. And Deepak Chhetri has appeared in that suit. And he had accepted that he has taken electricity line on that same plot of land.
I am not for Deepak Chhetri, my lord.
Deepak Chhetri has sold to Rajat Singh Roy.
No, my lord.
The power of attorney, he has sold that land to Deepak Chhetri in the year 2019.
19.
Yes, your lordship.
So this is a fault. Where is the power of attorney?
My lord, the power of attorney is in the supplementary affidavit.
Lordship, if you...
My lord, page 4 onwards is the power of attorney.
So you have given this for whole 43 decimals.
Whole 43 decimals, I had executed a power of attorney in favor of Rajat Singh Aure. But subsequently in the year 2017, I personally executed a deed in favor of my lord, firstly.
So then there is a case made out.
My lord, how can there be a case?
No,
my lord, not for the same plot of land.
At the same time, you have 43.
Yes.
Out of that 5 you have sold.
No. Firstly, I have executed the power of attorney. Then, my lord, I sold.
The revocation of the power of attorney.
My lord, that power of attorney is with regard to the balance plot of land.
Where is that? Show me. Where is that? Show me in the power
My lord,
of attorney.
Sees the power of attorney.
How much you have given land?
Yes, 43 decimals.
I thought you have 43 decimals only.
My lord, I am the registered. My lord, gives me 2 minutes, I'll clear the fog. I am the registered owner of 43 decimals. I execute a power of attorney because of my absence in the city. I execute a power of attorney in favor of one Rajat Singh Aure. That 43 decimals comprises of different LR plots. Now, my lord, in the year 2017, I am approached by the complainant personally. So I execute a deed personally with regard to a particular 5 katha, which is within a specific boundary. LR plot numbers, my lord, 493. Only LR plot 493. Subsequently, on the basis of the power of attorney, which was in favor of Rajat Singh Aure, he executes a deed of sale with regard to a completely different plot of land.
Where is the different plot?
Yes, my lord, I've shown it to you, lord.
Show it from the power of attorney that this Rajat had the what power have you given to Rajat?
Yes, my lord. Sees. The power is, my lord, schedule of the land at page 9. Schedule of the land at page 9 of the supplementary affidavit. All that pigeon parcel of vacant land measuring 43 decimals in LR Khortian 49.
These 5 katas is within the 43 decimals.
5 katas within the 43 decimals. The other 5 katas also within the 43 decimals.
Whatever it is, that you have 43 only.
Yes.
So 5 decimals, if you have sold, if you are selling it to somebody,
yes,
then these 5 decimals Rajat cannot sell.
No, he did not sell those 5 decimals, my lord. That is what I was showing.
This is different thing, sir. But you have 43 only.
Yes.
You give power of attorney for 43.
Yes.
And also sell the land within that 43.
Yes, because I'm the registered owner, my lord.
So how can you do that without revoking the power of attorney?
My lord, then we are getting into a civil angle, my lord. I
No,
need
but
not,
then-
I need not revoke the power of
significant,
attorney, my
sir.
lord. I need not. If somebody approaches me personally for executing a deed of sale, I execute that deed of sale. So
But
essentially what that leads to is those 5 katas of land automatically goes away from the power of attorney.
I understand 43, you want to have 2 sellers for whole of the property.
No, my lord.
Obviously.
If somebody approaches me personally, my lord, if somebody approaches me personally, then I am executing a deed of sale with a particular. Let us say, my lord, this is the 43 decimals. I have executed a power of attorney with regard to this entire 43 decimals, which is of which I am the registered owner. Now, my lord, Rajat Singh Haure possesses a power of attorney with regard to this entire 43 decimals. Somebody approaches me personally for executing a plot of land.
So that you sell within that 4315 kata, na?
My lord, within LR plot number 493 only.
You have 43.
Yes.
You have 43 decimals.
Yes.
This property falls within 43 decimals.
Yes.
Number 1. You have sold the land. Rajat has also sold the land.
Not the same land, my lord.
You are now taking up this plea.
No.
Without revoking power. That is why I have said.
My lord, had Rajat sold off the land that I had already sold off.
Minus 5 kata from this 43. You show me.
My lord, had Rajat sold the 5 katas, which was already sold by me, then a case would have made out.
Rajat is made out.
Rajat has sold a completely different plot of land.
How?
Because 2 boundaries are different,
Where is
2 boundaries are common.
No, how can both?
And my lord,
Once you have given a power of attorney.
Yes.
How can you sell the land without changing the subsequent power of attorney? That
My lord, law does not prevent anything. Power of attorney, my lord has to see the basis.
Prevent an offender also to commit.
My lord has to see. My lord, just give me two minutes. My lord, law does not prevent me from selling off my own land. I may have given a power of attorney to someone.
No. Once you have given the power of attorney, then you have got to revoke the power of attorney. Otherwise, the power of attorney holder.
My lord, he has the power of attorney with regard to the plot of land that he actually has the power of attorney on. So what is now?
Once you sell off the property, you must revise the amount of land.
Yes, that should have been done. Revision should have been done. But
that is the case.
But the case would have been had the same plot of land been sold by Rajat Singh Haure.
You are trying to make out, sir.
No, my lord, I am showing the 2 deeds from the documents. It is his plot which has 2 different boundaries and 2 common boundaries, 2 LR plots. Rajat Singh Haure executes a deed of sale which has only 1 LR plot. It is only within LR 493. That itself clears the confusion. And my lord, the second confusion that is cleared is 2 boundaries common, 2 boundaries different. So
I don't understand. Why don't you revise the amount of land in the power of attorney?
My lord.
Once you decide to sell off the land,
yes,
and an existing power of attorney is there with another person,
yes,
then automatically either you have got to revoke that power of attorney. In the alternative, you have got to revise the amount of land referred to in the power of attorney.
My lord, the power of attorney precedes the execution of the deed. Power of attorney was in the year 2016. The first deed was executed in the year 2017. It precedes the
power of attorney was.
So it was already there for 43
decimals. Then you had to revise that, sir.
My lord, if I did not revise it, the entire 43 decimals, if I did not revise it, is there any criminality to this? That is the question I asked to myself.
Yes.
2 different plots of land. Had the same land been sold off by Rajat Singh Haure, then my lord, a criminality could have been attributed towards me.
That is your defense, sir. That is your defense. Otherwise, no case would have been registered. Why did you first culpability arise once you don't revise the plot of land to a today also this power of attorney exists?
Yes, this exists. So if he sells off,
he continuously goes on selling off that 5 kata of land.
No, my lord, not that 5 kata. Different plot, my lord. Different plot of land. It may be within the 43 decimals.
You are taking up a plea. Does a power of attorney prevent is Rajat to again sell that same 5 katas of land?
No.
He has done that.
No, my lord. He sold off different plot. He sold off a different plot of land. It is not the same land for which I had executed the deed of sale.
You can parallelly sell off both of you. Rajat can sell 43. You can.
His sale will be void. His sale will be, if he sells off, then according to section 48 of the Contract Act, priority of contract prevails. If he sells off a subsequent.
But the persons who have been deceived, they would obviously come up before the criminal.
My lord, they have not been deceived. That is exactly the point that I'm trying to make out.
The happiness is
they have not been deceived, my lord. There is a boundary dispute, my lord. They have not been deceived. These are two different plots of land, and she says that she has a structure over that land. My lord, she has a structure over that land, my lord. The possession is with her. She has filed a civil suit.
Deposit, ready to deposit 5 katas. I can't pass injunction order. What is the price of the property of 5 katas, sir?
My lord, in that, the last transaction was, my lord, the 2019 deed says 14,30,000. 14,30,000 in the year 2019, more or less the same value now, my lord. More or less the same value. The government value, this is Champashari, my lord, outskirts of Siliguri. Outskirts of Siliguri, my lord.
Whatever it is,
My lord.
market value assessed by the ADSR, you will deposit 8 before the civil court, then only you will be granted anticipatory.
My lord grants me 1 day accommodation. Let me come back with the instruction.
Only to that extent, no argument.
My lord, the Supreme Court has deprecated such.
The answer rejected.
My lord, let me come back with instructions. My lord, one day.
Then rejected, sir.
Tomorrow I'll come back. The market value assessed by the ADSR, I'll have to deposit in the civil court. That is the condition, my lord.
But that must be ensured, sir.
Yes, my lord. I'll come back tomorrow with instructions. My lord, give me 1 day. Yes.
Yeah. Come back tomorrow, man. এটা not today করে রেখে দিন। না থাক।
With your lordship's leave, my lord, item number 86, both the parties were asked to submit their written notes of argument.
Wait. কত পর্যন্ত হলো 62? পাতাটা শেষ করো। পাতাটা শেষ করুন। 63. It's 64. 63, I have. Is
63, my lord, I am appearing for this statement, my lord.
yes.
Lord,
IO is present, my lord.
This is that matter where your lordship had directed personal appearance of my client, and as well as the IO, my lord. Lord, my client is present for that.
63.
Lord, Mr. Rahman is there. Mr. Rahman is present, my lord, the petitioner.
In which matter?
He is the principal of accused or what?
Yes, my lord.
He is the only accused.
Only sole accused.
Sole accused.
Yes, my lord.
Sole accused.
So ask him to meet with the IO.
Yes, my lord. He is present before the honorable court.
IO is present.
IO is present.
Ask them to meet. Come up after recess.
My lord.
What he has got to ask, there is nothing in the case. You were saying that he was saying IO demanding money. You are saying he is not attending the police station. This was
today report is there, my lord. Says that he was appeared before the police station, IO, without the notice.
My lord, yesterday he said that he did not appear. Now he is saying that he has appeared.
This is the yesterday's report. Two reports are there. IO is also present.
And IO present, you said you made a submission, he made a submission.
Yes,
yes.
I had to take a step. What is the?
I'm not the IO is giving contradictory reports as per my knowledge.
Yesterday he appeared.
Yes, ma'am.
Day before yesterday.
Day before yesterday.
Then why did you make that submission before court?
Because
as per the report,
the report was such that he did not appear.
Upon,
Today he is saying that he has appeared.
Next is the previous report. This is which are China.
Mixed the
last paragraph. This is the previous report.
Why are they trying to mislead the court, sir?
Not, I was present, my lord.
Why are they trying to mislead the court,
Yes.
sir?
I have seen, my lord. The two reports are different. Two reports are different. I have seen. My lord can ask the IO, my lord.
Mr. Chakraborty, this is the last circuit I am doing this, sir. Discipline your police force over here. This is interference with the administration of justice.
Same IO. গতকালকে একটা আলাদা রিপোর্ট আজকে আলাদা রিপোর্ট। Nonsense.
Naxalbari PS, I am telling you. Is it commissionerate?
No, no.
SP, that the.
Naxalbari is not SP Darjeeling.
SP that.
বদমাইশি করছি।
376. Actually, those.
But higher should be changed. And it is information to on the record of the SP.
কেসে কিছু নেই, কিছু নেই।
হাইকোর্ট দ্বারা রিপোর্ট দিচ্ছে নকশালবাড়ি।
You got the case diary, have you collected any document, materials?
My lord.
Mobile, any mobile seized?
No, my lord, he is still absconding, so
Who is absconding?
accused person.
And accused you require. Complainant makes an allegation. Where is the source? There are phone numbers given.
No, my lord, there is no serial list. No serial list, my lord. In the case diary.
Nijamuddin Mia interrogated.
Nijamuddin Mia.
This is the father-in-law of this lady.
No, my lord, Nijamuddin Mia is not interrogated.
It is the problem.
No, not interrogated.
What investigation you are doing, you tell me.
FIR হচ্ছে 25 মার্চ।
See, one thing, you have got to come out of that idea that only after arrest you will investigate. Those days have gone, sir, now. These are offenses you understand where custodial detention are hardly required until and unless overwhelming materials
Yes.
are there.
Yes, that's true. That's true.
By in view of the judgments of the Honorable Supreme Court, now you understand that heinous offenses you arrest, nothing is there. Nobody, that arrest, custodial trial, nobody will interfere. But in cases of certain offenses which are fluctuating, these are all fluctuating relationship-based offenses.
Yes, admittedly.
And if you want to find out that the material which can implicate, these are digital materials which are required.
Yes.
Your IO knows how to retrieve digital materials. Once a week meet with the IO.
Milord.
দিয়ে দিচ্ছে কি করে নেই মামলায় কিছু একটা রিলেশনশিপ ছিল ভেঙে গেছে আচ্ছা this court earlier directed the investigating officer to be present on the basis of which on the basis of the report submitted by the learned advocate appearing on behalf of the state. Yesterday on 18/6/2023, a report was submitted, which is diametrically opposite to the report submitted today. IE 19/6/2025. Acha. There has been a compliance prima facie EE with the notice issued under section 35(3)(e) of the BNSS. Having considered the same and the nature of the offenses complained of, as well as the materials collected in the case diary, I am of the view that the petitioner is entitled to get anticipatory bail subject to conditions being imposed. As such, 20,000 sureties of 10,000 each, 438(2), 482(2). Petitioner shall meet with the investigating officer of the case once a week from date till charge sheet is submitted before the jurisdiction. However, in case the petitioner surrenders or appears before the trial court and is granted bail, the jurisdictional court would be at liberty to alter, modify, or waive the conditions.
But the accused person is from Bihar, madam.
They will come and meet once a week, sir. What is bothering you till? I'm imposing conditions, sir. And I'm also giving, after some time, he can also file a modification application.
Yes.
Before that. Once he surrenders, that will be coming within the jurisdiction court.
Can I get back the reports? Now I have to talk with the SP.
Report, then you give photostat copy.
Yes, ma'am.
Something must be
I'm submitting the
report submitted by the state. Photostat copy of the report submitted by the state. We kept the report. Cholo, they share the Yes, what is your matter? Hold on.
75. Milord, it's all right, Milord. Can I do it tomorrow? It's a very short issue. Can I do it tomorrow virtually, Milord?
Who is your other side?
Milord, he's here, Milord. My Mr. Chakraborty and my learned friend for the defect.
That will take some time, I believe.
Tomorrow I'll do it virtually, Milord. Or next circuit, whichever, my lord.
Do it in the next circuit.
Right.
One line can be added, the personal appearance of the IO.
No personal direction was there.
But this was directed.
Orally directed.
Orally. Yes.
Then do it in the next circuit. He will also have to leave for Delhi.
Tomorrow I'll do it virtually, or next circuit, whichever. আমার voice আমরা ওখান থেকে কি করে আসছে? I'll then shut it off.
Mr. Chakraborty, Mr. Chatterjee, learning. Say 75 পার করতে হবে না পাই। Mr. Chatterjee, learned advocate, appears for the petitioner. Sir, your good name?
SK Saharia.
Mr. SK Saharia, please write it in a paper. Give it to my court office. Appears for the de facto complainant. Mr. Chakraborty appears on behalf of the state. In view of the paucity of time of Mr. Chatterjee.
As jointly prayed for by the parties.
As jointly paid for by the parties, list the revisional application. Revisional application. The revisional application be listed before all the next available.
I'm deep.
Just wait how much I can proceed. Let me see. When I will grant. Calcutta, I will not take anything. Whatever it will, Calcutta bench is very heavy bench, I'm telling you. Whatever I have to do, I'll do it over here only.
My lord, I am appearing in, my lord. My lord. My lord. My lord.
None appears
My
for the
lord.
petitioner.
My lord,
State
I am
who is the
appearing.
state is there.
My
You are
lord, I am
appearing.
appearing. My lord, I am very sorry, my lord. My lord, I am very sorry. Could you please give me? My lord, I am appearing in item 53. My lord, I am the objector in that case, and the order has been, the petitioner did not inform us that the matter has been listed before his honorable court.
কত
It's a
number?
matter of 33, my lord.
33, no, order has
33
been
already
passed.
order has been passed.
64
My lord,
leaving, none appears for the
for a
petitioner.
moment. It's not one matter, my lord.
Next second,
My
যা
lord,
হবার হয়ে গেছে।
my
64
lord,
নেই।
my lord, may kindly
None appears for the
let me just,
petitioner.
my lord, please.
State anybody appearing?
I'm
Oh, is there available? Learned advocate for. Next second, next second.
next second.
Yeah. None appears for the state wiki দেখুন। None appears for the, না petitioner আছে তো।
That is also the next second.
Petitioner-
State press for next.
আচ্ছা, learned advocate for the petitioner is present. However, learned advocate for the state aid pays for accommodation because of non-availability of the case diary. Release the application before the next available circuit bench. Next.
All 60 I'm praying for next circuit.
Learned advocate for the petitioner pays for an accommodation. Learned advocate for the state is present. नाम करो तुम दीजिए। Next circuit, let the application be listed before the next available circuit bench. Next. None appears for.
66 I'm for the city.
None-
I'm for the state, my lord, holding the city.
None appears for the petitioner. Learned advocate for the state is present.
Defect is also present.
Learned advocate for the de facto complaint is also present. List the application before the next available circuit bench. Next.
60 I am for the petitioner.
Who is for the state?
67.
67.
From the last 2 days, they're taken not today. Today also council is not present.
Learned advocate for the petitioner is present.
Lord sir, then tomorrow, Lord sir.
None appears for the state.
65.
হয়ে গেছে।
List the A before the application of the next available circuit bench. Next.
68.
My lord, I am appearing for the petitioner.
Who is for the state? You are for the state?
Yes, I'm for the state.
My lord, yesterday directed me to hand over the jewelries.
Hmm.
Accordingly, I complied your lordship's direction.
Done. Okay. Learned advocate appearing for the petitioner submits that the jewelries have been handed over pursuant into the undertaking given by the learned advocate appearing on behalf of the petitioner. Learned advocate aid for the state accept such contention. Acha, Caesar list is there, na?
Yes, my lord.
The Caesar list is available.
Thereafter, Jimana.
The Caesar list is also available in the case diary. It is not nil to. Nil Caesar list নয় তো?
No, my.
ঠিক আছে, তাহলে, হ্যাঁ। Something is there তো?
Yes, my
তাহলে
lord.
হবে, হ্যাঁ। নীল Caesar list, বল Caesar list আছে বলে নীল করো। আচ্ছা, in view. আচ্ছা। Caesar list is available in. The Caesar list is also available in the case diary in respect of the Caesars affected. Yes, in view of the petitioner having complied with the conditions, I am of the view that the petitioner is entitled to anticipatory bail. As such, the petitioner shall furnish bond of 20,000 with 2 sureties of like amount each, one of whom must be local to the satisfaction of the arresting officer. Oh, no, definitely case আছে। 20,000. তারপরে 432 আর 480 দিয়ে দেবেন। Petitioner shall meet with the investigating officer once in a week till charge sheet not submitted, na?
No, no, my lord, charge sheet not submitted.
Once in a week till submission of charge sheet. Once in a week till submission. The order of anticipatory bail will remain in force for a period of 6 weeks from date. Accordingly, CRMA 393 of 2025 is allowed.
Grateful.
My lord, I am for the petitioner. My lord, the case is, my lord, 5 years conviction by the magistrate, my lord, under the Wildlife Protection Act. My lord, that judgment was carried in appeal
কি
before.
হলো আলিপুরদুয়ার ঝাড় চলে গেল একদম পুরো আলিপুরদুয়ার গন
Did not turn up witness.
হ্যাঁ
Bad day for me. Here things didn't work out, their witness didn't turn up.
ফোনে বলে দিল ফিজিক্যালি যাওয়া পৌঁছলো না হ্যাঁ কনফারেন্স হয়েছে
কনফারেন্স আগে হয়ে গেছে মানে আজকের কনফারেন্সটা মানে আজকে ট্রায়াল কোর্টে যাওয়া হয় আগেরটা হয়েছে মানে আজকেরটা বড়টাই হয়নি
টাইম ইমপ্রিজনমেন্ট স্যার 5 ইয়ার্স তো কিছু করার নেই চলে আসুন তাই তো
14 months in custody.
The petitioner has been in convicted and sentenced for a term of, where is your order of conviction? A sentence, sir? It's a magistrate sentence.
15 to 30, yes, my lord, 30.
Wildlife Protection Act.
ম্যাজিস্ট্রেট তারপরে অ্যাপিলে গেছিল রেজিস্ট্রেশন
Appeal, my lord, the appellate court rejected my 389 application challenging that I am before it.
মার্ডার কেসে এ দিয়ে হবে এক্সাম্পল দিয়ে কখনো টার্ম ইমপ্রিজনমেন্ট হয় হ্যাঁ মার্ডার কেসে সাইটেশন দিয়েছে তো সেশনস কোর্ট
But page number 15 is the,
15.
yes, 1 5.
No, 15 is a starting point. Where is the sentence?
Oh, sentence, so 38.
হ্যাঁ কি বললাম
37 is the material portion, my lord. 37, third paragraph.
For a term of 5 years, along with fine of rupee is 25,000 ID for the period of 6 months for commission of offense under section 51 of the Wildlife Protection Act 1972. Acha. There is a further direction by the learned trial court while awarding the sentence, directing that 50% of the fine amount should be paid to Jalpaiguri Wildlife Division. Full stop. Be that as it may, being aggrieved by the order of conviction and judgment and order of conviction and sentence passed by the learned magistrate.
CJM, my lord, Chief Judicial Magistrate.
By the learned aids, Chief Judicial Magistrate Alipurduar, the in connection with our era in connection with
CR case number 332 of 2020.
where is that page?
My lord, page 15.
In connection with CR case number 332 of 2024, the petitioner preferred an appeal before all the learned district and sessions judge Alipurduar, learned sessions judge, by an order dated 10/4/2025. 10/4/2025 was pleased to reject the prayer for bail during the pendency of the appeal. Hence, the revisional application has been preferred before this court. One petitioner by the petitioner. Yes. ভাগ করে নিয়েছে দুটো হ্যাঁ ওকিলের কি চাপ হ্যাঁ Mr. Biswas, learned advocate appearing for the state, opposes the prayer for bail and supports the order passed by the learned aid sessions judge. I have considered the period of sentence so imposed by the learned aid trial court and having considered the same to be a term imprisonment and the petitioner already having suffered and submitted
14 months.
about 14 months of custody. I am of the view that during the pendency of the appeal, the petitioner should be released on bail. Accordingly, the petitioner shall furnish bond of rupees 20,000 from Bengal or some other state.
Bengal,
Accordingly,
Nadia.
the
Nadia district.
20,000, according to the petitioner shall furnish bond of rupees 20,000 with two sureties of like amount each, one of whom must be local to the satisfaction of the learned CJM Alipurduar. If on bail, once in a month, the petitioner shall report to the
69.
court of the learned CJM Alipurduar and obtain an acknowledgement. Such acknowledgement and be in every 2 months submitted aid by the office of the learned CJM to the learned appellate court, and such condition would continue till disposal of the appeal. Chalo. With the aforesaid observation, the revisional application being CRR 2 of 2025 is disposed of.
I'm great.
Same prayer in the next one.
Yes, my lord.
Which is the number? Next number.
70.
70 एक ही order. CR number same or different?
Same.
Two accused person. Or एक ही order.
Hello.
$71 Mr. led by Mr. Bhattacharya is online.
Yes. What have you done regarding the D? Huh?
Report on.
So what are you relying upon in this case? Untrained অবস্থায় YouTube channel কিছু তো দিতে হবে। All right, let it go for hearing. I'm staying the proceedings for the time being. All right.
It will already let it stay continue with that or let it rest for hearing. That is sure.
The order dated.
You don't have one cybercrime officer in each of the police stations. That is already happening actually. So if there is so, then this should be retrieved actually. এত ভালো একটা SDF বিল্ডিং এত ভালো একটা করেছে ডিজিটাল ল্যাবরেটরি করেছে সেক্টর 5 এ
That apart from that, fundamentally there is no cognizable offense. Anyway, Lordship can decide this.
আচ্ছা petitioner has challenged the proceedings arising out of Darjeeling Shodor Police Station case number 26/24 dated 15/4/2024, wherein on conclusion of investigation and charge sheet was submitted before all the jurisdictional court. The statement of the witnesses AAs have been also enclosed along with the revisional application. Full stop. Learned advocate for the state submits a report and the case diary has also been produced. I have assessed is the nature of the accusations made and the same relates to Khobor magazine YouTube channel. Acha. This court confronted the learned advocate appearing for the state as to whether any digital evidence has been collected, to which it was responded to that the learned advocate submitted on instructions that the same is not available. Having considered that the YouTube channel was by way of an electronic medium, and the same is required to be placed before the court by way of electronic evidence under the relevant provisions of the BSA. The BS Indian Evidence Act under the Indian Evidence Act. I am of the view that the petitioner has made out a case for hearing. Accordingly, the petitioner is directed to serve on the opposite party. Number 2, de facto complaint have you added?
Is a party.
Accordingly, petitioner is directed to serve a copy of the revisional application on the opposite party number 2 by speed post AD. Let the revisional application appear under the application in the available circuit bench commencing available circuit bench in the 3rd week of July 2025. There shall be an interim order of stay of the proceedings till 31st of July 2025. Serve copies. Report submitted be kept with the record.
Highly objected.
Lordship, I am for the petitioner.
Yes.
72 minutes, I am filing the notes of arguments.
For the state.
যন্ত্র এখানে আর ওখানে আর কিছুই হয় না।
You have received the copy?
Yes.
Written notes you have received?
Yes.
How will you deal with the written notes? Tell me.
Lordship, 3 decisions
Not applicable to this case.
not applicable to this case. One is Captain Singh and Uttar Pradesh. It's a different context. When there is trialable allegation, and another is when there is allegation and evidence, and another is CBI correctness of defense can only be going to after appreciation of evidence. That is a different context. All these 3 issues raised by my learned friend practically not applicable, and from it is well known to the honorable court since Anil Mahajan to till date, the authority is when there is civil dispute, then there is no criminality. So all these authorities
The petitioner has challenged the proceedings arising out of Meteli EPS case number 171/2024 dated 11/9/2024 under section 406, which was registered for investigation under section 406, 420, 34 of the Indian Penal Code. The investigating authority You have concluded or investigation going on?
Investigation going.
Acha. The investigating authority on receipt next paragraph. The investigating authority on receipt of the information furnished by
Ila number আসলো
one Nityananda Saha, address is to the Inspector in charge, Mateli Police Station, registered the case. Also, the allegations made in the letter of complaint, which has been treated to be the first information on the report of the case, are to the FAA that the informant was a purchaser and requested aid the petitioners, namely Ganesh Prasad Kushawa and Shambhu Shah, SH, to purchase AA's green tea leaves, for which he gave a sum of rupees 3,29, 22, 206.00. And after such payment was made, some tea leaves were supplied, but after 24/7/2023, such supply was stopped by the accused persons. The petitioner, in a tabular manner, has expressed the time period of payment so made. 8 and 8 1, 2, 3, 4, 5. এটা 29 নম্বর পাতায়। হ্যাঁ, এক থেকে 5 পর্যন্ত সিরিয়াল নাম্বার আছে, একটু বলবো। আচ্ছা, আচ্ছা, it is further contended that such that an amount of rupees 1,77 and 84, 332
2000
was equivalent in the year. ওটা হয়ে যেত, তারপর কি বললো? Paid for 6,00,096 kgs of green tea leaf in the year 2023 for 1,07,547 kg which tea was delivered, which had value of rupees 35,16,674, and the same was duly paid. The total amount being rupees 2 lakh, 2 crore 2,13,01,006. Out of the total amount of rupee is 3,29,22,206. The total amount paid was rupees 213,01,006. There has been an outstanding amount of rupees 1,16,26 21, 200. Acha. The informant on several occasions sent reminders for supply of the goods or to return the amount, but for the outstanding amount, neither there has been any supply of green tea leaves nor the due amount has been returned. Full stop. The informant therefore alleges that with some ulterior motive, such amount has been misappropriated by the accused persons and as such requested the inspector in charge to take appropriate steps against the accused persons. Full stop. Next paragraph. Learned advocate appearing for the petitioner challenge is the very initiation of the initiation and the further continuation of the case as the present case, as according to him, for recovery of balance amount of due, no criminal case has could be initiated as the informant has failed to make out any case that there was any deception from the inception of the transactions, and there were continuous business transactions for which major supply were affected, and for reasons beyond control, the further supplies could not be affected. Full stop. Additionally, it has been submitted that the case which has been made out by the petitioner is for evading the regular remedy is available under the civil law, and the process of criminal courts, process of criminal law has been misutilized with the purpose with the purpose of wreaking vengeance for recovery of outstanding amount. Learned advocate A8 appearing for the opposite aid party number 2 has submitted written notes of argument, wherein it has been contended that the accusations made in the FIR, if accepted to be true, the same makes out offences under section 406 and 420 EE of the Indian Penal Code. Reliance has been in place upon state of Chhattisgarh versus Aman Kumar Singh, 2023, 6 SCC 559. And it was submitted that an investigating process should not be scuttled by taking advantage of the draft of the letter of complaint. Achha. It was further submitted that since investigation has commenced, it would not be appropriate for embarking upon an inquiry to test the genuineness or reliability of the allegations made out in the FIR. Full stop. Additionally, it has been submitted that there has been embezzlement of funds to the tune of more than ₹1 crore. And the petitioners have petitioners are enjoying the say money. which calls for an investigation to continue as offences under section 406, offences under section 406 and 420 of the Indian Penal Code is made out. Acha. Learned Advocate 8 has also relied upon the judgment of Kaptan Singh versus State of UP 2021 9 SCC 35 and held that the allegations which have been made makes out triable offences, and as such continuity of the investigation is required. The reference has also been made to CBI versus in Khanna. You want to say anything?
No, I'll just stand up.
Reference has also been made to CBI versus Arvind Khanna 2019-10 SCC 686. And it has been contended the correctness of the defense can only be gone into after appreciation of evidence. Learned Advocate 8 for the state has placed the case diary and submitted that since investigation of the case has already commenced, the state agency must be allowed to continue with the investigation, and a logical conclusion should be reached after the whole process of materials are collected by the investigating officer. Full stop. I have taken into account the submissions advanced by the Learned Advocate 8 appearing for the petitioner, the state 8, as well as the opposite 8, party number 2, /8 de facto complainant. Full stop. Prima facie on an assessment end of the accusations of the allegations made in the letter of complaint which was addressed to the inspector in charge of Metallic Police Station. I find that there was a continuous business transaction between the petitioners and the de facto complainant. The same would be evident from the subject matter of complaint which has reference to 2 financial years. Full stop. It is also admitted in the complaint that out of a sum of rupees 3.29 crores, goods oblique green leaves worth 2.16 crores, bracket approx were also sent and were also delivered to the de facto complainant / informant. The case has been initiated for the outstanding / balance amount of rupees 1.16 crore. Considering that an FIR has been registered only for assessing the charges under section 406 and 420 for outstanding amount, I am of the view that a civil dispute has been given the color of a criminal proceeding. There was continuous business transaction. As such, there cannot be deception from the very beginning. Subsequent non-payment cannot give rise to a case under section 420E of the Indian Penal Code. And if there has been a case of non-payment of a part of the money, then the same would amount to breach of agreement, for which appropriate remedies would be available before the civil court. Having considered the same has been settled by the Honorable Supreme Court in the case of G. Sagar Suri একটু নিয়ে নেবেন আমার কাছে পরে citation and subsequent decisions. Having in regard to the totality of the circumstances, particularly the basis on which the foundation on which the case was registered for investigation, I'm of the view that the same was for the purpose of recovery of outstanding dues, which cannot be permitted by setting the criminal law into motion. Consequently, I am of the view that further continuance of the proceedings arising out of Metal Police Station case number 171/2025 dated 11/9/2025 is an abuse of the process of law and as such call for interference of the
Lordship 24.
24
Oh, yeah.
এটা ভুল লিখেছে হ্যাঁ ওই মেটেলি পুলিশ স্টেশন কেস নাম্বার কত
171 up to
2024 dated 11/9/2024. Consequently, all further proceedings relating arising out of one Meteli Police Station case number 171/24 dated 11/9/2024 is hereby quashed.
Grateful, Lord.
Thus, CRR 68 of 2025 is allowed. Case diary be returned to the learned advocate appearing for Mr.
I'm deeply obliged.
I'm for the opposite party number 2, Lordship.
Next. Yes. Yes.
My lord, for the petitioner,
আর কত করবো এ তো
then next circuit, my lord.
কেউ-
Then kindly extends the interim order which was there.
Lordship, I filed an application for vacating the stay, Lordship, because material suppression of fact has been done while the stay was obtained, Lordship. There was an application for cancellation of bail, Lordship, and that has been suppressed and this stay has been.
It is there, a part of the record that was not pressed.
Lordship, kindly come to.
The certified copy of the order says that it was not
May I?
pressed. Kindly seize, my lord, the order
My-
dated 30th of April 2024.
কি আছে জিআর কেস
Here, case, my
Lordship.
lord. In the
What
time
case?
of, my lord, I had purchased tea from the complainant. Now, some payments were made, some payments, the checks were bounced. And subsequently, my lord, this police case was started.
এই তারাইটি কোম্পানি তো প্রচুর মামলা আছে একটা মামলা থাক না পরে সার্কিটে হবে
My lord. Then kindly extend this
My
claim, my
Lordship,
lord.
regarding the extension of stay, I have objection, Lordship. Kindly come to page number 30 of my application, Lordship, CRAN 1.
I have not received a copy of that, my lord.
Affidavit of registration.
you have made some payments
Some payments, admittedly, my lord, in the written complaint, it is there.
I'll check that একই মামলা আগের মতোই নাকি not like
That was different, that was advance.
oh
And this.
This is after, after
Advance for
purchasing,
purchasing green leaves, tea leaves.
and this is not green, black both.
This, advance
I am
for
not
tea.
bothered continuous transaction or one transaction
No, continuous transaction. for a lot of transactions.
continuous
Yes, madam.
Continuously.
continuous transaction এখানকার থানাগুলো পড়ে তাহলে এক্সেল
হ্যাঁ আমার interim orderটা ছিল that can may kindly be extended.
yes what is which application is vacating
Last application for stay, Lordship.
and in number
CRAN 1, Lordship.
And one not with me. আমাকে দিয়েছে।
Service to which?
grand one what is your grounds of vacating
Lordship, there was material suppression of fact
where
that.
is that paragraph material suppression cannot be a magic word sir you have got to
They have,
which paragraph
Lordship, I am showing it.
I don't have. আমার কাছে।
দেখাচ্ছি, দাঁড়াও। Lordship, at page number 6, paragraph number 12, Lordship.
yes
There was an application for cancellation of bail that has not been mentioned, and by that way, the stay.
Your applicant opposite party states that he had challenged the aforesaid order dated before this honorable court and the same as registered its CRR number 31 of 2000. Application was taken up for hearing. And again, this is
Pending, lordship, still pending.
তো দুটো একসাথে ট্যাগ করে দিয়ে করে দিয়েছি টেক্সট
Lordship.
আচ্ছা
Copy নেই, CRR, I don't have a copy. দেওয়া আছে।
serve the copies upon them the CRR
Service has already been done, I shall serve another one, lordship.
আচ্ছা
একটা দিয়ে দিও
the de facto complaint
অবশ্যই।
opposite de facto complaint opposite party number 2 oblique applicant in CRAN 1 of 2025 is directed aid to serve a copy of the application of CRR 31 of 2025 to the petitioner in the present revisional application. Full stop. Since CRR 31 of 2025 is still pending before this honorable court, I direct that CRR 31 of 2025 be heard along with CRR, the present revisional application being CRR 133 of 2025. Consequently, CRAN 1 of 2025 is disposed of. The interim order earlier granted is extended till 31st of July 2025. List the revisional, both the list CRR 133 of 2025 along with CRR 31 of 2025 before the next available circuit. Next. Next.
These are the 306 matter which was heard, my lord. Today's fees for order, my lord. Lordship, I am for the petition in item number 74, lordship. Father and mother of the principal accused.
এই সবাই একটা করে বড় হয়ে গেলে যাতে ঝামেলায় পড়ে যাবে আমার মনে হয়।
Genesis of the FIR was that, lordship, allegedly our son
Do it in the next circuit, sir. হবে না। Incomplete.
Lordship, very small matter, lordship, if you lordship can
And small matter means, see, about 89 matters are there in the list.
Lordship.
They have got to complete these things before they go. Is there any interim order?
Yes, lordship, there was an interim
So,
order
I
first.
mean, let the interim order continue. Do it before the next one.
Already, my lord, heard.
I know, but then there's
Again, we have to.
shortage of staff, sir. We don't, had there been other, I don't have any problem, sir.
So if you,
For me, the dictation is not a difficult.
lordship, tomorrow.
সব 4:30 ট্রেনে টিকিট কেটে রেখে দিয়েছে স্টাফেরা হাইকোর্টে। দিস ইজ দ্য গ্রেটেস্ট প্রবলেম। দিস ইজ ওয়াই আই এম টুমরো। করতে পারে আবার এটা ওই আছে আর একটা ওর ম্যাটার আছে তো ওইটা কতগুলো
হবে না,
হতে পারবে
ক্রিমিনাল
না রিভিশন ওটা হবে না। সিডি আসেনি
সিটি জাস্ট চার্জশিট, শর্টলাইন চার্জশিট।
only the charge sheet was missing. The interim order earlier granted is extended till 31st of July 2000 হবে না 31st of July 2025. The revisional application, let the revisional application appear before the next available circuit bench. Is ready be returned to Mr. Chakraborty Lane, advocate appearing in the state. এখন করতে গেলে 4-5টা স্টেটমেন্ট কি না তুলতে হবে, তুলতে গেলেই তোমার 10 পাতা হয়ে যাবে।
Actually, lordship, hearing was conducted last time, that's why.
Sir, but this is a difficulty. If I take this to Calcutta next 3 months, I will not be able to take up. The bench is over there.
Lordship.
Next time, if I come, it is lying, I'll do it. On the first day, mention the matter, I will do it, sir.
All right, lordship.
Past week, there is no hearing. This is the difficulty. All pressure comes in second last day. This is the difficulty.
If possible, lordship, for tomorrow, if possible, lordship.
Not possible, sir. There are, tomorrow I have already kept to be mentioned 2 and 3, ওই ground of arrest দুটো রেখে দিয়েছি। That's a greater problem, much more greater problem.
All right, lordship.
এটা একটু ফেরত দিয়ে দিন না। কি আছে? এই নেক্সট সাইকেলে করুন, আর হবে না। List the appeal before the next available circuit. Learned advocate for the appellant, but you appear. Learned advocate for the appellant as well as the state is present. List the appeal before the next available circuit bench. পরপর 3টে একই অর্ডার করে দাও, নামগুলো দিয়ে দাও, হবে না। বুধবার রাখবো বলে বুধবার হলে তাও হ্যাঁ হ্যাঁ নামগুলো দিয়ে দিই। 78টা বোর্ডে দিয়ে দাও। Seventy-eight, oh yeah, I will give the name, 79 you are appearing.
No, 78.
28, next circuit.
79? Actually, this is that matter.
I understand.
5 years, not 3 and 5 years. The human rights.
Next circuit হবে না। এগুলো শেষ করা খুব মুশকিল হয়ে দাঁড়াবে, যা সকাল থেকে হচ্ছে। দেখে দাও ওই একটা অর্ডার দিয়ে কার আছে, ডাকো 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 ডাকো।
79 for the petition, my
For
lord.
the OP number 2.
But as per my lord's direction on the last occasion, both the parties have filed the written notes of arguments, my lord.
But unfortunately, I could not prepare the written.
ঠিক আছে।
My lord, I think they argue on behalf, somebody filed on behalf of my learned CNFN yesterday written notes of arguments for the opposite party number 2.
No, no, keep going. No, no, my lord, I have not prepared. How can I say?
Affidavit in reply has been filed, with
Yes.
notes of argument has not been.
Yes.
My lord, last occasion I filed the written notes of arguments for the
Your written
petitioner.
notes of argument is there. Actually, written notes of argument filed by the petitioner yesterday has been retained with the records. Learned advocate for the opposite party number 2 prays for an accommodation to file the written notes of argument. Learned advocate for the state is present. In view of the accommodation sought for, list the revisional application in the next available circuit page.
But let a copy be served upon us, the written note, so that we can give.
Have you
Sir,
served
do
the?
No, no.
No, no, I have not served. Matlab, they were also supposed to file, they did not file. So may I kindly give a direction upon them to serve a copy upon us.
We'll
when
also
they-
serve.
when they written-
Next.
Wait for me.
Lordship, I'm praying for next, sir.
Learned advocate appearing in for the petitioner prays for accommodation. List the revisional application in the next available circuit bench. Chalo next.
So I'm for the petitioner, Lordship.
Buffalo case, my lord.
It is that Buffalo case.
হবে না এখন, come to the.
Only the release of Buffalo Lordship, they are already out
Acha,
of 18 Lordship,
why-
one has already been died. On
Acha,
last occasion, Lordship had.
Release of the vehicle to.
Not vehicle,
Huh?
Buffalo. Vehicle has already been released.
No objection was in relation to.
No objection has already been given in respect of vehicle.
So the vehicle has been released.
Released by the trial, local London magistrate. Now the issue is the release of the Buffalo. Kindly,
But then last time it was for the vehicle you were wanting, sir.
no.
They have showed the photos of the vehicle that 18
Yeah.
buffaloes kept the
The
accident.
point of consideration was
My
that
lord,
whether the vehicle was customized in accordance with law or not. That was the question. At Lordship, I'm giving this, the relevant rules and the existing status of the vehicle. That according to my,
How many buffaloes were there?
18 was there, now one has died, 17 that day.
No, I'm not bothered about that. At the relevant point of time when the offense was committed, 18. This customization was according to what are there is an area provided for each animal to be kept under the cattle trespass act.
Yes. So according to the provision of law, one cattle should be measured to be weight for 200 kg per cattle.
No, no.
Area, total length area is 25.72 square meter.
No, for each animal.
One square meter. 1 square meter. So the now 1 square meter, if
18 square meter.
18 square meters যে গাড়ি হয়।
গাড়ি ছবি।
In meters, tell me what is the
kindly see the
32 feet though.
square meter also. I'm given both area square foot and square meter also. Square foot is 272 square feet.
This has to be assessed. You have taken away the vehicle. Transportation of animal rule. So where is the document of this? This 25.72. This is the typed copy, sir.
Which one?
This is from where? This is you have prepared.
Yes.
So where is that vehicle document which shows that it is 25.72 square meter?
Vehicle document is at page.
Page 42.
Vehicle seizure list is at page 42.
And the vehicle has been seized. This specification of the vehicle.
Specification of the vehicle, Lordship, that photograph is there, Lordship.
Yeah, photograph. That what you have written. RTO document is there.
RTO document, Lordship, I'm checking it out. Driving license is at page 32, sorry, 32, 30.
I'm giving you file a supplementary evidence.
You can see at page 35.
What is there?
35 is.
দেখো দেখছি এখন আর বলছি যে
No, no, I'm
20 I want this answer, sir. 25.72 square meter is there. So what is the chassis of the vehicle is concerned? আর কিছু আমার চাই না। You file RTO documents, sir. You have it with your client, definitely. Petitioner is directed.
Oh, that's difficult, Lordship. About one thing, Lordship, may I say one thing? Lordship, that has already.
Then I'm disposing or go and before the SCGM, I'm giving this direction.
Or SCGM already dealt to it.
I am directing the SCGM that he would see you have represented 25.72 square meter. 18 buffaloes were there.
Yeah, there.
Whether first he will check the specification of the vehicle. Thereafter, under the rules, 18 buffaloes can be customized in the vehicle. He will check and then accordingly take a decision. Otherwise, the next circuit. Otherwise, if I don't have the papers, I will not do it.
Challan, all documents are there.
I'm not on that, sir. There is a case under the cattle trespass rules. You yourself has said that 1 square meter is available for each of the.
Only apply one mind. So I'm submitting one thing. Only one thing as per the law. Provision. Kindly see at relevant rule 50 of my that the copy I have just handed over. Where the 6.9 into 2.4 is a vehicle size length. Table 2.
Regarding the release of the cattle, my lord, because as per the reports, they are in a pound, my lord. So khatal type. So one has expired, my lord. So report may be called for or in.
I am not on that, sir. First, let them satisfy this court
that the vehicle
the offense was not committed. Because once an offender cannot be returned the cattle answer. So that's a confiscated. You have got to give those goshalas and all those things that you have got to give it to them.
Only kindly see the table 2. Table 2.
Yes.
Yes. Only the kindly see vehicle size length into wide square meter 6.9 into 2.4. Floor area of vehicle square meter 16.56. Where 16 number of vehicle has been permitted to carry. Is it okay? Now, kindly see the specification. I'm written here. My body and length is so and so. Area is 2.272 square feet or square meter to 25.72 square meter. Now, kindly see even 20 the total carrying limit is 25 buffalo. However, 18 buffalo were carried. So according to in terms of the total length and breadth.
So that supporting document you show me that your vehicle had 25.72. There must you purchased the car.
Yes.
There must be a blue book of that vehicle.
Exactly.
The floor area must be specified in the chassis over there. So show me that only. I'm not wanting something more from you, sir.
That is not readily available, Lordship. This
File a supplementary, 2 options I can use.
True. But meanwhile, Lordship, interim custody may be released.
The offenses
offense, Lordship, this cattle has been died, Lordship. They have been purchased against consideration. I have annexed all the challan. payment receipt was there. One has already died, lordship, I have suffered loss. Who will compensate, lordship? The case is not, even the, no offense has been committed. Police has given report to that effect. Police were demanding the money. It is my instance that SOP was.
These are additional points, sir. You
No,
said.
not I, sir. I'm beseeching your lordship.
Sir, in your terms, I cannot dictate, you cannot dictate what I.
Certainly, let's say,
I have said, I've asked you, clarify me, make my conscience clear, order is yours. Whichever party is before me. I don't have a strict, rigid, any notion, neither towards a lawyer nor towards the litigant. I'm giving you two options, either file supplementary affidavit or I can dispose of, you will file such application before the learned aid magistrate. These are the two options.
May I take one documents to inspect lordship, page 85. This is a permission of the interstate transportation of the cattle from the West Bengal to Meghalaya to of the Assam. So interstate transportation permission. Kindly see, it has been given by the government itself.
Sir, indirectly I will.
And where this specific,
show me the.
my vehicle has been, my vehicle number was there. Kindly see at page 85. Once. Prima facie, lordship. What is calling for your lordship? I understood, but it is not readily available, lordship. That's why I'm beseeching your lordship to see once, only once.
So I'm wanting a simple document, sir. That should be with your client, sir. That should be. Learned aid advocate appearing for the petitioner insists for return of the seized cattle. However, the was registered under the relevant provisions of the BNS as well as the Protection of Cruelty to Animals Act 1960. Having regard to the provisions for which the prosecution, for which the investigation commenced, and the contention of the petitioner that all the conditions were complied with. Relevant documents be produced before the court by way of a supplementary affidavit in respect of the number of buffaloes being carried, which is compatible with the area of the vehicle in which the buffaloes were being carried and has been seized in connection with the incident case. Full stop. Let a supplementary affidavit to that effect be supplementary. Let a supplementary affidavit to that effect be filed by the petitioner within a week from date. Advance copy of the same be served upon Mr. Chakraborty, learned advocate appearing on behalf of the state. A report be submitted within. For tarik ta kobe theke 28 tarik theke na
30th
30th of June. Within a week, you give the supplementary affidavit to Mr. Chakraborty. Mr. Chakraborty within a period of 5 days would get a report from the investigation. 5 days. It would be preferable that the revisional application be listed before the next available circuit bench. On the date of reopening later the next before on the date of commencement of the next available circuit bench.
So interim order may be extended because there is a interim order of stay of the inter proceeding that has been expired lordship on 10th.
The interim order earlier grant CRN 3.
Yes, 3.
The interim order earlier granted 8. When was it granted?
It was granted on 25th of March. 25th of March.
25th of March this year?
Yes, this year.
The interim order, the interim order earlier granted is extended till 31st of July 2025. The interim order earlier granted. Is extended. Accordingly, CRAN 1 of 2025 is disposed of. Copy next.
CRM 3, CRAN 3.
CRAN 3 লিখেছো তো?
CRAN 3.
Next.
My lord, I appear on behalf of that matter for restoration of PWDV. The state was directed to serve.
They were not found. That location.
My lord, kindly restore the PWDV matter, my lord, because it's a matter of bread and butter, my lord.
Restoration, sir.
Because the appeal was heard on the day it was. My lord, may I hand over the.
But how come I've directed service, but how come this is maintainable, sir? You tell me. The revisional application,
My lord,
how come? No one appears on here.
my lord, because on that day the appeal was heard and we were of the notion that the LC had traveled to the sessions judge. And after a while, when we were aware that the LCR did not travel and the appeal was being heard without LCR, by the time we come.
Where is that point?
My lord,
Paragraph?
My lord, paragraph number. My lord, paragraph number 10. 10, paragraph number 10. My lord, to that effect, I am tendering the list of dates, my lord, because on 18th, the appeal was heard, my lord.
The next day, the appeal is also dismissed.
But the appeal is not dismissed, the appeal is still in abeyance. By the time we were of the notion that.
Appeal is before the appellate court.
Yes.
So you should have taken up this point over there. Why are you coming to High Court? I don't know.
Because, my lord, the suit was dismissed. The complaint was dismissed.
The complaint was dismissed. The appeal court, under section 29, you could have added the appeal and not the appeal. Yeah, I can look at.
My lord, as the kindly restores the matter, my lord.
But this is an appealable order actually. That is what I was from the inception here. If you take it as a complaint case one, you don't take it as a complaint case also under the
PWD, yes. But my lord, the appeal, if my lord 528 does not bars my lord to.
No, but then appeal, this is the problem now.
Because my lord, if we again go and appeal out there, then this 20 subsection 6 would again go in abeyance. Then they will take a longer time to decide, my lord. Because my lord, see, my lord, even the state has to be engaged for service. They are not receiving, they are playing this hide and seek game. More than 40,000 rupees is pending, my lord, till date, and they have not paid a single penny.
Sir, if it is dismissal under 256, that is also appealable. If it is under the DV Act also, that is appealable. Now you come under 482. 482 is a second option over here, sir. If the appeal court doesn't do anything. Unnecessarily, these ladies you are harassing. এখানে আসার কোনো মানেই হয় না। Report submitted by the state BE kept with the record. The report reflects that the আরে বাবা কি করেছে কার এগেইনস্টে মামলা
My lord, respondent number 225, my lord.
Responded to it.
whom have you gone to serve?
Respondent lordship.
Written petitioner. See.
We are the petitioner.
দেখো এবার কি আমি ঝামেলা
My lord, we are again in problem. My lord, kindly restore. I beg your lordship.
Yes, my lord.
Then, my lord, a liberty may be given to approach the appellate court because
you go to the next available circuit. Let them serve. Wrongly serve the people.
The problem is that, my lord, we are not getting a single penny, and I am suffering
so
from.
Then I am giving you the liberty, sir, under section 29. Because you see, they have gone and searched for the petitioner.
Then, my lord, keeps it in next circuit.
Whichever is available. I don't.
Keeps it in next, kindly ask the state to serve the response because they are not taking from us, my lord. That's the only problem.
Acha, the report submitted petition again. যেমন পুলিশ তাও দিচ্ছিলাম অর্ডারটা দাও I don't want to keep matters pending.
Yes.
I could have easily anyway or the other.
My lord,
But this is a difficult, so this would be.
My lord, may I?
Our right has accrued to a person by way of dismissal. That I cannot do without giving an audience.
My lord, may I request one thing, my lord? Keeping it in next circuit, my lord, kindly fixes a date for the next circuit because
Reopening. On the date of reopening.
On the date of because otherwise again mentioning and that cause this will be a very
Unfortunately,
getting to address.
Unfortunately, the state has effected service upon the petitioner, although the direction was to serve upon the private respondents. Full stop. The concerned officer would, the learned advocate for the state would direct the concerned police station to effect service upon the private respondent numbers 2 to 5. Now, what 2 to 5? মহা জ্বালা হলো আমার 2 to 5. আচ্ছা, let's a survey is be completed by 27th of June 2025. A report be submitted by the state on the next date. So fixed list the revisional application on the date of commencement of the next available survey. Report submitted be kept the record.
My lord, it is that matter regarding
land dispute.
Next, sir.
Learned advocate aid appearing for the petitioner, de facto complainant, as well as the state is present. List the revisional application before the next available circuit letter. None appears for the petitioner or the state.
State is not there.
Or the opposite party. None appears for the petitioner or for the opposite aid party. List the revisional application for the next available circuit bench.
My lord, I don't have paying for next circuit, my lord.
Learned advocate for the petitioner prays for an accommodation. Learned advocate for the state is present. List the revisional application for the next available circuit bench next.
86 and for the petitioner's honor.
For the de facto complainant, man.
Person to the opposite direction and written notes.
Well, it might written notes of that. এইটা না এটা de facto
This is that matter where the bank officials were involved in a 306 matter.
আরেকটা কোথায়? Charge sheet submitted.
Charge sheet submitted.
It is there.
EMI collection. এটা একটু ই করতে হবে, হ্যাঁ EMI collection ব্যাংকের এমপ্লয়ীদের দিয়ে দিস বিষয় ওই একই হলো। এটা একটু বার করে দিন, এটা এমন ভাবে আমি বার করতে পারছি। বাইরে আছে এই কে আছে এখানে বলো তো পিওন আছে ও ওকে বলো তো এই জাজমেন্টটা আছে ওইটা একটু অন্য আমার টেবিলের উপর আছে এই যেটা তোমরা করবে 306-এর উপরই আছে ওটা
Performing their official duty. And this is their contention. And also people also standing in the side note. The inside note is compared with the handwriting of the description found by the handwriting. Both are
Matching.
first. The suicide note is full of having the existence of the six. Now, if the your lordship is, the offense, the act committed by the accused, accepting the profitable offense, cannot be protected under the guise of the official duty. Or the duty cannot be given to them when the act amounts to the profitable offense under the guise of official duty. Either relied on one judgment, where the Honorable Supreme Court has been clear about the term and guideline. What will be the action of the agents or the employees of the non-banking finance company or the bank in order to collect their loans from the borrower. So, the guidelines which have been given there, that has been violated. So, that judgment I have another judgment I have relied on my lord stated that these non-banking finance company or the employees of the bank, they will not get the indemnity under section 197 of the Code of Criminal Procedure.
তোমরা যে জাজমেন্টটা করলে সই হয়নি
These judgments I have relied, and my also submission by your lordship, the suicide note has attracted the all the ingredients of 306. And they cannot get the under the guise of the official justice. And I have relied for judgment of that. And there's a requirements, specific guidelines of what to do, what not to do by collecting the amount from the workers. That has been close to that.
চলে আসুন The present divisional application has been preferred challenging the proceedings arising out of Kotwali Police Station case number 241 of 2024 dated 2/4/2024. Under section 306-34 of the Indian Penal Code corresponding to GR case number 1573 of 2024, wherein the investigating agency on completion of investigation has submitted a charge sheet before the jurisdictional court. The accusations as is reflected aid from the brief facts of the case stated aid by the investigating officer reflects as follows. The informant's father, Kalidas Haldar, took loan of is 9 lakhs from Cholamandala Finance Limited. And for 1.5 years, he failed to pay the EMI amount towards the said loan. Acha. For failure of repayment of loan, the accused persons created mental pressure upon the complainant's father and his family members. As a result, for about a week, the complainant's father stayed outside their house. And on 31/3/2024 at about 5 hours, 054 hours, the said Kalidas Haldar consumed alcohol at his working place, that is Datta Bhai Dharmakata, Mohit Nagar, Holdibari, to commit suicide. Full stop. He was admitted at Jalpaiguri Super Specialty Hospital. And on 4/4/2024, at about 17:00 hours, the victim died. And before his death, he penned down a suicidal note. The complainant, as the informant of the complainant, as such, believed that that because of mental torture inflicted by the representative of the non-banking financial company, his father committed suicide. So over the incident and the information furnished, Inspector in charge Kotwali Police Station initiated the case, and after commencement of investigation, the investigating officer visited the place of occurrence, examined the available witnesses, recorded their statements under section 161 CRPC. And also seized one green and white color plastic container containing small quantity of liquid, original suicide note of Kalidas Haldar, one exercise book green covered containing written page, with separate pages signed by the witnesses under proper scissor list. Full stop. The Bearhead ticket was collected from Jalpaiguri Medical College and Hospital. Full stop. The expert analysis reported that the writings and signature are of the same person. Full stop. It was also ascertained in course of examination of different witnesses that the deceased Kalidas Haldar took loan of rupees 9 lakh from Cholamandalam Finance Company and failed to pay EMI in the month of March 2024, when the accused and the company, when the accused being accused persons being the company when the accused persons being the company's representative pressurized him to pay the amount, and started mentally torturing him day by day. Full stop. As a result, deceased consumed poison to commit suicide. Full stop. Acha. Learned advocate aid appearing in for the petitioners. Submit a that there is no credible evidence of provocation or incitement by the accused persons. Neither there is proof of direct or indirect acts of incitement, instigation, conspiracy, or intentional aid that led the victim to commit suicide, which is essential in case of an offense committed under Section 306 of the Indian Penal Code. Full stop. Additionally, it was submitted that the complainant has admitted that rupees 9 lakh loan was availed of from Cholamandalam Investment and Finance Company against equitable mortgage of plot number 1448, LR Khatian number 3133, 3134, LR jail number 18, Moja, Patkata village, Nayabasti, PS Jalpaiguri, as security of the mortgage deed. It was also the tenor of the complaint according to the petitioners reflect that the deceased failed to repay the monthly installment and towards the outstanding loan, and consequently the loan account was declared as a non-performing asset. The family, the informant has, under the garb of repaying, instead of repaying the loan amount, initiated the instant proceeding for shielding himself from the liability, and the persons who have been implicated in the incident is were working and performing in adhering by way of adhering to their duties further the suicide even if the contents of the suicide note taken as a whole is presumed to be correct, no offense under section 306 of the Indian Penal Code has been made out. So far as the petitioner is concerned, who happened to be branch business manager, recovery officer, area business manager respectively. Next, learning aid, advocate aid for the private aid opposite aid. Learning advocate aid for the petitioners to continue in order to fortify his arguments relied upon Geo Varghese versus State of Rajasthan, Nada 2021-19, SCCE 144. Shaila Singh, SHAILA, Shaila Singh versus State, 2023 SSC Online, CHH 4132, Chhattisgarh. Rohit versus is the state of Maharashtra. An unreported judgment end of the Bombay High Court. As well as a coordinate judgment of this court in CRR 10 Tushar Manna versus Anand Sarkar, bracket CRR 1072 of 2020. Learned advocate A8 for the private opposite party number 2 oblique de facto complaint end on the other hand submit a that the original suicide note which has been seized by the investigating authority itself reflects that due to constant pressure and humiliation as well as unbearable mental torture inflicted upon the deceased by the accused persons, the father of the de facto complainant was forced to commit suicide. Consequently, the charges of abetment into sustain and as such, the finding of the investigating officer under section 306 of the Indian Penal Code were in strict adherence to the provisions of law. Further, according to the de facto complaint of the party number 2, the QDEB examinations, which on comparison and analysis arrived at a conclusion that the handwriting and signature handwriting and signature in the suicide note are of one and the same person. As such, the proof at this stage of consideration of charges at this the proof at this comma at this stage as such the proof at this stage of at this stage of consideration of charges comma have been established by the investigating agency and interference at this stage may result in abuse of the process of law. So factually, it has been canvassed on behalf of the de facto complainant that the victim only failed to pay the installment in for the month of March 2024. For which the high-handedness of the bank officials led to the untimely death of the father of the de facto complainant. Full stop. The plea, further the plea of discharge in further the plea of the accused persons relating to discharging the official duties cannot be accepted as the modality is in respect of the bank authority is for recovery of the loan amount has been laid down by the Reserve Bank of India. Learned advocate as such submits that the prayer of the petitioner for quashing of the proceeding at this stage would deprive the de facto complainant of the informant to establish his case in a court of law. Full stop. In order to fortify his argument, learned advocate relied upon 2009 6 AIR Bombay Bomb 276. Next, and AIR 1998 SC 1945. Yellow. Learned advocate for the state, on the other hand, has produced a case diary and supported the case and cause of the de facto complaint of the party number 2. It has additionally been submitted that the prosecution, in order to prove its case, has relied upon 10 witnesses. 6 of such witnesses are persons who have been privy to the act and action of the bank officers, as also the sufferings of the deceased. Full stop. The recovery of the suicide note, which is reflected even in the report under section 173 of the CRPC, would go to show that the prosecution has made out a watertight case, which calls for progress and termination of the KAAs at the stage may result in gross failure of justice. You got a index over here. Suicide note is on which page, sir? ये बोझा तो विराट मुश्किल है. You have a copy enclosed. This is your complaint. This is the it is আমার এই মর্মান্তিক পরিণতির জন্য I see you suicide note there. Let me just apply my mind the last clause. ঠিকঠাক আমি করুন তাও যেখানে বুঝতে পারবো আর দেখবো না। কি বললাম এখানটা? So the submission. I've considered the submissions advanced by the learned advocate for the petitioners. The state aid as well as the learned advocate appearing for the defect complaint. Before proceeding, we the overall assessment of the case. I am of the view that since the parties to the litigation have emphasized on the suicide note, and analysis and assessment of the same is required. The suicide note, the contents of the suicide note, which has been referred to in the case diary, was in the form of a letter addressed to the inspector in charge of Kotwali Police Station, Jalpaiguri, which read that the outcome of such fatal incident is because of Cholamandalam Finance, who were responsible as for default in only one installment. They have been harassing him, Vakari deceased, and all his family members. It was further contended that on 30th March 2022, at about 10:30 p.m., the petitioners, by different means, tried to mentally torture and harass the deceased. So, one Shubhankar Deshwar, along with three to four of his associates, came at his residence and harassed him. It was further stated that according to the rules, after evening hours, the recovery agents of the finance agents of the finance company cannot approach the person who has taken loan, and and the recovery agents of the said finance company had also been to his place of work as he was unable to face the torture and humiliation. He was compelled to the administration to complain and prayed that his statement maybe consider to be a first information on report. Okay. The process, the learning, the case diary or the charge sheet also reflects that the prosecution and prosecution has also relied upon ten witnesses, amongst whom five of the witnesses, apart from the complainant, stated that the six witnesses. So five witnesses apart from the son. Son is the complainant. কি বললাম? That the that the accused persons had been creating pressure for repayment of the loan and to that extent they had been calling up the DCEs and stated and threatened that if the deceased could not repay the amount, he would commit suicide. I have taken I have taken into account বলেছি নাকি এটা statement of দেখে নেবেন এখন বলে দিই তাহলে মাথাটা গুলিয়ে যাবে I have taken into account the statement of the witnesses, the suicidal note, the submissions of the learned aid advocates, as well as the judgment aids relied upon by the learned aid advocates appearing for the petitioner. Learned advocate, a petitioner and the de facto complaint. Learned advocate for the de facto complaint has relied upon the rules of the Reserve Bank of India for recovery in respect of loans, as well as the judgment reported in AIR 2000. No, 2009 6 AIR Bombay, na? 2009 6 AIR Bombay are 726 25 number page 25. আচ্ছা বললাম এটা very in paragraph 6 of the Code of Banks Commitment to Customers, BCS BI code pertaining to collection of dues provides as follows. তো পাবে এটা করতে পারবে এখানে scan করতে হবে। এটা দেবার দরকার নেই অল্প কি বললাম খালি জাজমেন্টটা রাখবো কিন্তু ভালো কি বললাম প্যারাগ্রাফ 6 বললাম ওটা দরকার নেই vary in the vary in paragraph Wherein in paragraph 13, the Honorable Bombay High Court was pleased to record that RBI has expressed concern about the number of litigations filed against the bank in the recent past for engaging recovery agents who have purportedly violated the law. Acha. The Reserve Bank of India in the letter accompanying in April 24, 2008 has stated the guidelines on engagement of recovery agents. Full stop. Ashram. Learning advocate for the de facto complainant has also relied upon the judgment end of the Honorable Supreme Court in Muhammad Hadi Raja versus State of Bihar and Nadar, PIR 1998 AC 1945. To sanction it, okay. Which paragraph is sanction judgment though? This is not a public sector bank. Why is it? The sanction, that is sanction protection. Very in the Honorable Apex Court was pleased. Wherein the Honorable Apex Court was pleased to hold that even in the protection of sanction cannot be afforded to a delinquent bank official purporting to act in discharge of his official duty. Very in an offence has been committed. The petitioner has relied upon, learned advocate for the petitioner has relied upon the judgment of Geo Varghese Supra, which dealt with the contents of the suicide note. In paragraph 39 of the said judgment, it was observed as follows. Judgment Act, para 39 তে বলি। চলুন। আচ্ছা। And in order to appreciate the overall circumstances of the case, wherein an offense has been alleged to have been committed under section 306 of the Indian Penal Code, the thrust would be on the issue relating to abatement. The parameters which of abatement which have been stated under section 107 of the Indian Penal Code refers that a person abets the doing of a thing who instigates any person to do the thing or engages with one or more other person or persons in any conspiracy for the doing of that act. Full stop. The explanation to the provision, the explanation to the section 107 of the Indian Penal Code also states that any willful misrepresentation or willful concealment of material fact may also come within the parameters of abatement. Full stop. In the instant case, if we assess the materials collected by the investigating agency, admittedly, there has been a loan, comma, a default which has admittedly there has been a loan. The deceased was a defaulter, and the present petitioners, being officers of the bank, demanded the amount for which there was default. The present petitioners are, according to the records of the prosecution itself, associated with Cholamandalam Finance and Investment Company. And the same has not been disputed by any of the parties. Also. The petitioners now the suicidal note, which is the very fulcrum of the prosecution case, and wherein it has been stated that immense mental torture and harassment was inflicted upon the deceased for recovery of the loan, and which subsequently the investigating officer relied upon for charging the present petitioners require an assessment. Full stop. The amount of loan which was the overt act of the petitioner as such would be relevant for assessment. In this case, so far as even if the suicidal note is accepted to be true, what is found on the victims and victim from the disease contention and that there was harassment inverted removed and mental torture. The said mental torture and harassment was for the purpose of demand of the loan amount. Full stop. The petitioners were officers of the bank who had the authority to demand the amount. They had, the nature of mental torture. Has the nature of mental torture and harassment, which has been in the genesis is for foundation of the present case. As such is to be assessed on the background of the loan which has been taken. Consequently, what is important at this stage is to assess the sensitivity of the person who claims that he has been subjected to mental torture and harassment. Mayor repeated demands or steps taken for recovery of loan without any overtax which have not been expressed by which has not been expressed in the materials available in the case diary or that relied upon by the prosecution will not amount to abatement until as each and every person have different reception and their sensitivity towards any statement or abuse would be different. I have taken into account the locus of the present petitioners who are bank officials, the suicide note as claimed by the prosecution and the de facto complainant, the statement of the witnesses, and the background of the case which had its genesis is in the loan which has been taken by the deceased. Having considered the act and action complained of against the petitioners and the charges for which they have been called upon to face the trial, I am of the view that the prosecution has failed to make out any case for abatement, which lay aid to the commissioner of suicide of the deceased. Consequently, I am of the view that further continuance of the proceedings arising out of Kotwali PS case number 241 of 2024, dated 8/24/2024, would result in abuse of the process of law, and the same as such is liable to be quashed. Consequently, the further proceedings of the force aid case is quashed. The revisional application on the CRR 187 of again in Bulli Kitchen application 2025 is thereby allowed. Connected application, if any, is consequently disposed of. Case diary may return to the learned advocate appearing proportionally. কালকে দিন হবে মানে অর্ডারে লিখে দেবেন tomorrow you will take back the case. এটা নিয়ে হ্যাঁ just 1 minute late information you are from Dr. The state would seek an explanation through the investigation of the case with regard to the incident that suggests you have come for what? Oh, actually. What does it mean?
So just this it says it's rather a simple or rather simple or
and you have come up for what are you wanting? Charges to be enhanced. But the 323, it is not, some injuries are there. Now, multiple.
It's from the Jalpaiguri Government Medical College.
I am believing this leading to tissue and this lacuna. So it can be done that is. Oh, neither simple. Oh, simple it does not as well. So, the honorable. Oh, neither simple. Simple নয় বলছেন 323 আনা যাচ্ছে না কি হয়েছিল কি অ্যাকচুয়ালি This is what I have asked them to actually clarify. This was a private institution, Mediview. So this is for which I asked this clarification. So at this stage, how can I, sir? Thank you, appreciate. You were relying upon this multiple lacuna infraction, so and so. It's a medical term, sir. I don't understand, at least up to this step. So I sought for a clarification from the government hospital. Now they say this is neither simple nor grievous. So, not a so it can be concluded these lacuna infracts were just an incidental finding relating to coexisting medical conditions stated above. The doctor have kept under what they say, the ICC they look at for observation. No exception. It is not a read court, sir. I will dispose of the application if I will give you this. I will give this liberty to the court that in case material surface in course of evidence, court after the evidence. This will delay the proceedings. Learning advocate, pursuant to the direction earlier passed, the a report has been submitted by the inspector in charge, Kotwali Police Station, Jalpaiguri. আচ্ছা, clarification was sought for in respect of এইটা একটু দেখে নেই তো 14 নম্বর পাতায় না এই একটা টার্ম মাল্টিপল ল্যাকুনা ইনফ্যাকশন এই গন্ডগোল হয়ে যাবে কিন্তু in left sided brainstem and right basal ganglia region হ্যাঁ একটু ফ্ল্যাগ করে দিচ্ছি এইটাকে লিখে দেবে হ্যাঁ এখানে লিখতে consequently the consequently a report was obtained from Jalpaiguri Government Medical College and Hospital and to that effect it has been observed as follows এইটাকে এইখান থেকে এই পর্যন্ত দিয়ে দেবে আচ্ছা I have taken into account acha learned advocate for the petitioner submits that petitioner was in hospital father of the petitioner was in hospital for about 5 days after the incident because of the injuries inflicted at his head full stop having considered the same having considered the oral evidence, having considered the submissions advanced by the learned advocate for the petitioner, and on an assessment of the findings of the medical board, the medical board, na, of the medical board of Jalpaiguri Government Medical College and Hospital. I'm of the opinion, I'm of the opinion that no interference can be made at this stage. But however, in case oral evidence supported by other materials to substantiate the case of the petitioner in course of the trial, the learned trial court would be at liberty to add, alter, or amend the charges. I've seen that. মাথায় বলে তাই জন্য আমি এতটা এই করলাম with the aforesaid observations, the CRR 209 of 2025 is disposed of. Reports are submitted be kept with the record. A copy of the report be handed over to the learned advocate appearing for the petitioner. Give it to him. Eighty-eight who is appearing? Yeah, charge sheet has been have you obtained the charge sheet? Charge sheet? So you take back this, case diary, give that case diary to me. লেখা হয়ে যেত বাড়িতে এটা আজকে নিও না কালকে দিও আজকে নিতে সময় লাগবে কিন্তু এটা অনেকগুলো হয়ে গেছে পরে তুমি এগিয়ে নাও কাজ হ্যাঁ কোর্টে বসে লিখে গেলে তোমার অসুবিধা বিয়ে চলছে আজকে এগিয়ে রাখবো কাজটা tomorrow I'll pass the order, sir.
Order where the complainant there's no objection to the number 5. It has been observed that
Sir, the anticipatory bail observation has got nothing to do with challenging a person. Tomorrow I'll pass the order. I just give a glance and I'll pass the order tomorrow. Appear virtually. Few matters will be there. Anytime it will be taken up. ঠিক আছে ওর মধ্যে সে দেখে এটা চেম্বারে পাঠিয়ে দিন হ্যাঁ ask somebody to stay আর কত দেখা
Bail order has been asked for lordship. Lordship has been asked to file a supplementary affidavit regarding the bail order, lordship.
Last matter.
Last matter,
No
lordship, only
matter,
just one
no more
matter.
matters, sir. I can only record. a
Lordship,
copy.
it will, if it will,
Supplement you will file by the record matter to appear before the next circuit bench.
matter, lordship, kindly, lordship.
আর হবে না।
Lordship,
I will go and
is
all
the
the
warrant,
orders will be
lordship,
mixed up.
we call the warrant, lordship. Lordship. Lordship, there is a no bail order was there in main petition. Lordship asked me to file the supplementary affidavit, lordship.
এই যে warrant of arrest নাকি? Warrant of arrest?
Lordship.
নিয়ে নাও তাহলে একটা। কত অনেক মামলা হলো তো এই সাইটে।
89.
এটা আমি সাপ্লিমেন্টারিটা দিই। আচ্ছা, learned advocate appearing in for the petitioner submits that the petitioner was earlier released on bail on or about 2/8/2019, and since the end, he has been following the learned advocate aid. However, he was never informed after the charge sheet was submitted, and as such, subsequently, a warrant of arrest was issued. Learned advocate aid undertakes that the petitioner is ready and willing to appear before the learned trial court. Learned advocate for the state is present. In case the petitioner appears before the learned special court or trial court. This before the special court.
Special court. NDPS.
Which court? Learned aid special court. Session judge, Darjeeling. Learned special court under NDPS Act and special court Darjeeling. সেশন জাজ বললে হবে না, সেশন জাজ চার্জ ছিল সেদিনকে, স্পেশাল কোর্টই হবে। আজ কবে? আজ কত তারিখ? 19 তারিখ না, 4 সপ্তাহ দিয়েছি। বাই 21st of July 2025. In that case, the learned aid special court would allow the petitioner to continue on the same bail and bond, subject to the condition that the petitioner shall not leave the jurisdiction
Darjeeling district, lordship.
Darjeeling district বড় হয়ে যাবে, থানা
Darjeeling Sadar, lordship.
Jurisdiction of the of Darjeeling Sadar Police Station.
Lordship.
If on bail, the petitioner shall once in a fortnight meet police personnel authorized by the inspector in charge of the officer in charge of Darjeeling Sadar Police Station till further orders are passed modifying the condition by the learned special court.
Not sure.
With the aforesaid observation,
Much obliged.
Sierra 266 of 2025 is disposed of.
Much.
Great. Circuit says.